out that the special leave petition preferred against the judgment passed in the matter of Arunima Paul stood dismissed by the Honorable Supreme Court on 21st July 2025 in petition for special leave to appeal within brackets C number 19222/2025. Stop. It has been contended that the court in Arunima Paul clearly laid down that by mere participation quote that by mere participation a candidate does not acquire any vested right. According to the Honorable Division Bench, only the disabled candidates and the candidates not specifically tainted were allowed age relaxation and could take part in the fresh selection process. Stop. Apart from the aforesaid two categories, no other category was specifically mentioned who would be entitled to such relaxation or concession in the fresh selection process to fill up the vacancies. Stop. It has been argued that once the issue has been set at rest by the court in the matter of Arunima Paul within brackets Supra, the said issue ought not to be re-agitated all over again. Stop. Next. It has been submitted that the list of tainted candidates has already been published and steps are being taken to disclose the details of the said tainted candidates in terms of the order passed by the court. Stop. Paragraph. The matter is at a very preliminary stage. Stop. For effective adjudication of the instant lists, the parties ought to be given an opportunity to disclose their stand by way of an affidavit. Stop. The respondents may file their stand by way of a report supported by an affidavit. Stop. As an interim measure, the court is only at this stage, at this stage, the court is considered. The court is considering as to whether any interim relief can be granted to the petitioners. Stop. The Honorable Supreme Court in Boishaki Bhattacharya within brackets Supra permitted the candidates not specifically tainted, permitted the candidates who participated in the 2016 recruitment process and who are not specifically tainted to be eligible to participate with appropriate age relaxation. Stop. It is an admitted fact that the Commission has not yet published any list of candidates not specifically tainted. The Honorable Division Bench in the matter of Arunima Pal also took note of the fact that it is the candidates not found to be specifically tainted who may be permitted to take part in the selection, in the fresh selection process with relaxation. Stop. In the absence of a list disclosing the names of candidates not specifically tainted, the Commission possibly cannot restrict the age limit only to the candidates who have been found whose names do not appear in the list of tainted candidates published by the Commission. Stop. The candidates in the recruitment process of the year 2016 has now to be taken as two sets. One of the tainted ones whose candidature the Supreme Court has not approved of and has kept the tainted candidates specifically out of the selection process. And the rest, the untainted candidates, have been directed to participate in the recruitment process. Stop. The division bench in Arunima Pal was also of the same opinion that the untainted candidates be permitted to participate with age relaxation. Stop. It does not, none of the orders passed by the courts, either by the Honorable Supreme Court or the High Court, mention that the untainted candidates or the candidates not specifically tainted should be restricted only amongst the candidates who were given appointment. Stop. It may be the candidates who did not get appointment because the tainted candidates were put up in the list for the tainted candidates were provided appointment. Stop. Had the tainted candidates not been given appointment, many of the other candidates who are not specifically tainted could have got the job. Stop. The court, time and again, has reminded the Honorable Supreme Court, time and again, reminded that the High Court should be mindful of not allowing any of the tainted candidates to participate in the selection process. Stop. The same implies that any candidate who's not specifically tainted would be entitled to participate in the selection process. Stop. In view of the above, the court is of the prima facie opinion that at this stage, the commission ought to publish, not at this stage, the commission should immediately publish a list of candidates not specifically tainted so that they may take part in the fresh recruitment process if they choose to do so. Stop. The candidates who do not fall within the list, who do not fall in the list of tainted candidates, but are included in the list of the candidates not specifically tainted, be permitted to take part in the recruitment process with appropriate age relaxation. As the last date for filing the application form has been extended till 8th December 2025, the commission shall take steps to publish the list prior thereto so as the candidates not specifically tainted can participate in the recruitment process with appropriate age relaxation. Stop. The let the matter appear in the list on 6th January 2026. When in January the other matter was fixed. 6th January 2026. Prior thereto, the pleadings of the parties be concluded.
Just to
But I am praying for stay of operation of the order.
Affidavit of service and court fees, and another thing is that Orunima Pal matter is regarding Group C 9-10 matter. This is Group C, Group D. Kindly note that. And another thing is that I want to cite just one judgment. Although it is in compilation, because of the third party can.
1 minute. Affidavit of service ke record রাখবেন. Deficit court fees receipt দেওয়া আছে. This will be taken on record. Mr. Bandyopadhyay has prayed for stay. ওটাকে রাখুন. Yes.
Orunima Pal matter is regarding 9-10. This matter is a non-teaching. Group C, Group D. Rule is separate. The challenge is by the separate
principles are same. Principles of law are same.
আরেকটা paragraph add up করুন. Specific contention of the respondents is that the rule pursuant to which recruitment was being conducted for assistant teachers in classes 9 and 10 and 11 and 12 was under challenge in Orunima Pal within bracket Supra. ঠিক আছে? Be it recorded that in the instant case, the rule which is under challenge is the West Bengal School Service Commission bracket open selection of persons for appointment to the posts of non-teaching staff bracket close rules, 2025. And though it has been asserted by the respondents that a similar rule was under challenge in the matter of Orunima Pal, but the court has noted that the Honorable Division Bench had specifically observed in more than one places that the rule is not under challenge per se, that the recruitment rules, 2025 per se is not under challenge. That's it.
Orunima Pal's rule is separate and this Group CD rule is separate. And the states of candidates is also better.
Anything else?
Well, since this, yeah, apropos to the last submission being made after the order, anyway, Malad, what my submission was that the principle of law will apply equally to both the cases, number one. And number two, Malad, I have also indicated from the compilation filed by the commission that the rules were in fact in challenge, Malad. That is at page 122 of the.
Mention that you assert that the rule is under challenge.
Yes.
The court has recorded that it is not under challenge.
Yes.
Now we go by the court's order.
Good.
Yes. And Mr. Bandyopadhyay, after the order is dictated in open court, the commission prays for stay of the same stuff paragraph as the court has the court has considered such prayer and refusing to stay the order passed herein above. ঠিক আছে? একটু পাঠাতে হবে।
But ABDB service and court fees
Yes, yes, that will be taken on record. এগুলোকে রাখবেন ফাইল।
Next matter.
Yes, next matter, please.
Next matter, ABDB of service and court fees kept on record.
In the next matter,
Yes,
item 8.
8.
Yes.
But this matter is also Group C, Group D, but in the same line of Polash Noskor with an extra prayer. What is that extra prayer and why? Prayer Polash Noskor I already handed over, my lord.
আচ্ছা এর আগেরটাতে বোধহয় পলাশ নস্করটা আছে, ওটা দিন তো, ওটা কাজে লাগেনি।
May I hand it over again?
ওটা কাজে লাগেনি। না মোটাটা না, একটা পাতলা অর্ডার, দুপাতার অর্ডার, ওটা না ওটা না ওটা না। হ্যাঁ 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 হ্যাঁ।
Polash Noskor আছে extra. But may
Yes,
This compilation also your lordship keeps with your lordship.
একটু এইখানটা
ওই কম্পাইলেশনটা দিয়ে দিন, 15 থেকে মামলা করতে লাগবে।
এটা এখানে থাকুক, পরে ওটাকে চেম্বারে পাঠাবেন।
you know.
Yes.
My lord, in this line, my lord, I have a prayer. Although I challenge the rules in Polash Noskor matter also. In this matter also, my lord.
Is পলাশ নস্কর pending?
Yes, yes.
Yes, 6 January.
6 January. 6 January. Yes, my lord. Because of that, my lord, this 10 marks argument is going on, my lord. In the same line, rule is challenged. 5 marks is also challenged. That is given for the experience marks. But in this matter, my lord, although tented list and untented list is already Polash Noskor matter, my lord, pass that order, my lord. But my lord, one thing is that is not yet, my lord, published by the West Bengal Central School Service Commission. That is counseling wise list in the 2016 selection process. Why it is required?
Not in the prayers.
I remember there is specific prayer.
No, there is no interim prayer with regard to that.
Yes, but prayer H is that, my lord. My lord, why?
There is final relief.
Why
I'm sorry.
my submission?
Yes, I'm sorry.
Sir? Why that is required? Because of that, my lord, in Vivek Paria matter, Supreme Court says not even a single tented candidate slipped through the net, my lord. But kindly turn page number 130.
Was পলাশ নস্কর challenge?
No.
Not yet. Not yet. As per my information is subject to correction. My lord, kindly turn page number 130.
130?
Yes, my lord.
Yes.
There are 4, one after another, that is West Bengal Central School Service Commission, when the panel expired, my lord, in 4 category, Group C, Group D, 9, 10, 11, 12. Some of the counseling, in case of just, my lord, in the instance of 11, 12, that is 5,712 posts, publication of final vacancy, thereafter date of publication of final panel 27th November 2017. Panel validity for 1 year, that is ended on 27th November 2018. Thereafter, my lord, kindly see the date of first counseling, 16/7/2018. Thereafter, second counseling.
All after the expiry of the panel.
Expect first and second. The third onwards.
Yes.
Third onwards, all are after expiry of the panel.
Yes, 19.
Yes.
All after.
And the very next page, same line. Very next page, Group C, Group D. In the same line, all after 2-3 counseling, my lord, all the counseling are after expiry of the panel. Now, my lord, I am placing the Supreme Court, my lord, judgment, my lord, para 30 and 31, which is annexed with my writ petition. Why I ask for this counseling wise list?
Page 130 is in respect of the Group C, Group D.
No, my lord. Page 130 is respect of 11-12. Page
This
131.
writ petition is about
Group C, Group D, at 132 and 133. I says it because of that combination. That judgment is combination of 4
Yes,
selection
yes.
process. That's why I annex the 4.
all right. But then 132 is Group C.
Yes, Group C, and 133 is a Group D.
All right.
So that's why I annex all these to showing that there is an expiry panel appointment, and Supreme Court take note of that, my lord.
All right.
I will place the Supreme Court judgment later on, my lord. So, my lord, in Group C, Group D also that is happened, my lord. So after panel, after expiry of the panel, there is an appointment, my lord. So they ought to publish the counseling wise list, my lord. Until and unless they publish the counseling wise list, how could because Supreme Court Vivek Parya matter is that might be in public domain. Until and unless it is in public domain, how could a candidate or any citizen ascertain who are that tainted candidate after expiry of the panel?
Want in this matter, you want the publication of
Counseling wise panel.
counseling wise.
Because before that, my lord, I just want to, my lord, canvass that Supreme Court judgment, page number 98. What was the Supreme Court observation regarding this expiry of panel? My lord, judgment start from
All right, page 98.
page 67, page 98.
Only one sentence I should say. Since
Who are you now?
our lordship is hearing the point of the expiry of panel.
Yes.
Now, this law point might get affected in the hearing which is continuing. All I say, lordship may pass any order because lordship is in the midst of it.
I may make.
Because paragraph 31 has been shown.
No, I am not 31. I am on 30.
Absolutely no difficulty. But all I request your lordship that kindly hear us on the point of expiry of panel and thereafter. Because prior to that, my lord, any kind of, my lord, slightest comment, my lord, that.
See, this is what I was thinking, and I'm making myself clear so that they also get to know. There is an issue of stigmatization which was highlighted yesterday, that if the list of the tainted candidates is published,
That is
then
what
these
tainted-
candidates get
Yes.
stigmatized. So why not publish the list of the candidates not specifically tainted? So at least for the time being,
No,
they can avoid the stigma.
But that's absolutely fine. I say different. List of the not specifically tainted, absolutely fine. List of even tainted, absolutely fine. But list of the persons who are not tainted, but might become tainted if lordship holds that after expiry of panel because they have been appointed. If that comes today, all I'm saying, kindly hold that part.
As of now, you are not in the tainted list.
I'm not in the tainted.
So if they publish a panel not specifically tainted, your name may go there.
There is no difficulty.
Thereafter, the court hears the matter
Yes, yes, yes.
and comes to a conclusion that the candidates who were given appointment after expiry of the panel will be treated as tainted, then your name will automatically go out from the list of the not specifically tainted.
Comes, there is a likelihood that if Mr. Mitro does not begin, it will come today. I will be able to, my lord, 100% show and satisfy your lordship. Out of 8 counselings, all the 7 counselings, those were found by the CBI itself, yes, after expiry. That's why it is illegal. but not tainted because of XYZ reasons recognized by the Honorable Supreme Court.
That
As and when it comes.
yes.
Right, right.
But then your apprehension
Yes,
that if you fall,
yes.
will be taken care of.
But so far as the list of untainted, no apprehension, no problem. So far as the list of tainted, no apprehension. Only apprehension is
Presently untainted, later tainted. That is the apprehension.
no. I would not even use that. List of candidates appointed, not tainted, but after expiry.
Yes, this the court has to decide whether it will be within the tainted list or not.
My response in one sentence: it has been
Decided.
decided.
Very well. The court will
Decided,
see.
that's what I'm saying.
You'll get a
But
turn
then-
and
My lord, and now, my lord, I place the
say that since Lordship is hearing, ultimately it's everything is, my lord, interconnected. So maybe I was little excited only for this reason, because once Lordship
no, I have followed
understand, it would be extremely difficult.
and
my
I
lord.
understand. I
That's-
understand your problem.
my lord,
Yes.
may I place?
Mm.
Because before that, my lord, because I'm a learned senior friend, my lord, intervene in this matter.
No, it's
I just yes, I am not. I just say that I am not asking for that after expiry of penal. I am asking for the counseling wise that might be that they are absolutely fine, but I am not asking for
That's
the
absolutely fine.
yes. I for that is the reconcilement. I am not asking for any expiry of the panel. My prayer is very restricted that counseling wise list. That's my point. The court might hold that
no.
yes,
So what is your prayer right now? You want the list of the
counseling wise,
panel as per the council.
counseling wise list. Because
Yes.
why I so kindly turn page number 98.
What is the primary challenge?
Primary challenge is rule, my lord.
Rule.
Rule 5 marks, 5 marks.
All right, that means the rules
that
itself.
means rules itself, my lord.
Right.
We call treatment
How-
and that tainted list as well as not specifically tainted
All
list,
right.
which is already covered by earlier order.
All right.
And
And you participated in the earlier recruitment process.
yes,
And
I participate in this selection process also.
yes.
But
Here you participate.
I want to participate, my lord.
Want to participate.
Yes. I want to participate, and there is no relaxation is required, my lord. I want to
You are
participate.
within age.
Yes, yes, my lord. And but I want, that's my prayer, my lord.
All
And
right.
but the counseling I want, my lord, the counseling wise list. And before that, kindly turn page number 98, my lord. Why I placed it, my lord. Page number 98, para 30.
But then, if the rule is under challenge and we can decide that, why is this list of counseling required immediately at this stage?
Counseling wise list, it be because of that, my lord. If my lord hold it, suppose my lord hold it, that there might be opportunity. Two things might happen. One is that my lord might hold that yes, up to 8 round of counseling, everything is okay and fine. That is separate thing. If my lord hold it, that no, after 3rd round or after 4th round counseling, illegal or expiry of the panel, then my lord, that list is required.
All right.
So that purpose, my lord, that before expiry of the panel decided, this counseling wise list is required. That's my prayer, my lord. Because it will not harm anyone, my lord. It is a very innocuous one. Because of that, they already, my lord, hold it. They gave appointment. Counseling wise, they gave appointment, and they might publish it, my lord. Counseling wise. And not only that, my lord, on instruction, although yesterday night, my lord, I searched it, I did not get it. By on instruction, I say so the board can appraise this court. After, at that point of time, up to 2nd round of counseling, board in their website, West Bengal Board of Secondary Education, although yesterday night I gone through it, but I not get it. Up to 2nd round of counseling, board in their official website uploaded whoever got appointment up to 2nd round of counseling. Board in their official website, they published. But after 2nd round of counseling, they never published it. That's my instruction, but it may be wrong. But yesterday night, I gone through the board's website, I not get it. Might be they withdraw it.
Yes.
Can I make my submission?
Yes, certainly.
Milord, kindly come to page 131, which he has cited. 130.
Yes, 130.
Very misleading statement is being made by the writ petitions. Page 130 is related to teaching and teaching staff. I mean class 9, 10, 11, 12. 131, 9, 10. Then 132. Group C. And Group C, kindly see, everything was done before expiration of the panel.
The last round is after expiry of the pen.
Wait, please wait.
You have said earlier after second round.
That is regarding 9.
After second round.
Yes.
Now, kindly see here, date of fourth counseling was 31st December 2018. Then number of vacancies so and so. Status of panel expired on 18 May 2019. Then before that. Then next one, 133 also, Group D. Date of fourth counseling was 31st December 2018. Status expired on 4th May 2019. There were his statement in the submissions of them. Then that's all it. 130 is concerned. But that will deal with in the teaching staff
Separate.
matter.
Yes.
That there was a stay of operation of the order, will deal with that. Therefore, whatever the submission is being made, that's totally to misguide this court, to mislead this only. There are a number of matters it has been done. Anyway, now for the timing it is there. Now, secondly, Milord, what is his legal right to ask for all the types of counsel? One of the most unsuccessful person is disturbing the court, is disturbing us. That is also not appreciated. This time he has filled up. Anything is wrong, that's a different thing. But it cannot be opened like an ocean. Simply because 2025 rule has been challenged. 2016 you are asking, not asking. He didn't ask from the 2016 when the writ petitions have been moved, Group C, Group D. Everything, every prayer was there in the earlier petitions. I will show it to your lords, which has not been allowed. Now he is asking, he want to open like an ocean. Therefore, my lord, I will make a request that your lordships should not kindly do not pass any interim order. My lord, your lordships have said regarding the tainted list of the tainted. We have published it. We have published it, and somewhere we are publishing. I've said. So far, the untainted is concerned. Also, my lord, we have, my lord, specifically untainted. It's a term is being used by the learned councils. Supreme Court has never said about specifically tainted or tainted. Supreme Court has untainted and tainted. And untainted is restricted to only the persons who are in the employment. All benefits should go to them, not to anybody else. Those who are in the waiting list, CBI has not made any inquiry. Then they are kindly direct the CBI who are in the waiting list, whether their candidate will come for tainted or untainted. CBI has restricted his investigation only to the persons who were in employment. CBI has not crossed the limit, and who are the unlisted, waiting listed candidates, no investigation was made on their case. That doesn't mean it should be treated that they are untainted.
Lord, if your lordship kindly comes to page 36. Page 36 for the writ petition, my lord.
Yes.
The prayer my learned friend is relying on, prayer H, is a final relief that he has claimed on the basis of pleadings, my lord, which your lordship may accept finally or not. If your lordship kindly takes prayers K, L, and M, my lord, none of these prayers are related to any category-wise publication of any list. My lord, the foundation of his prayer today is some people may have been engaged, appointed after the expiry of panel. As I have understood, my lord, because he may have made submissions, but I have not found any foundation in the first list, second list, first counseling, second counseling, etc. Ultimately, the buck stops that the panel expired on so and so date. Some people may have been appointed after that date. Your Lordship has already pronounced an order, my lord, in Polash Noskor, that is WPA 22580. Polash Noskor, sorry. The Polash Noskor WPA number is not, I'm sorry, 24996 of 2025. That is 1st December. Your Lordship will kindly take paragraph 10 thereof. Your Lordship has already directed the Commission that as regards the candidates who were given appointment after expiry of the panel, their details shall be produced before this court on the returnable date.
But this is in respect of only 9 and 10, isn't it? 9, 10, 11,
Polash
12.
Noskor
It is Group C, Group D. Kindly take
This is
paragraph
Group-
1.
Most
Oh, actually.
Group C, Group D, your Lordship has
Right,
already
got it.
directed the names to be produced before your Lordship, my
All
lord,
right.
those who were appointed after. Therefore, my lord, if his claim, my lord, as my learned senior, my lord, appearing for the commission already submits, my lord, if his claim is pertaining to people engaged after the expiry of panel, my lord, his cause of action was of 2018 and 2019. Therefore, his cause of action is not related to promulgation of the rules which is under challenge. The mere promulgation of the rules
All right,
does not
please.
give someone a right to challenge it.
just to indicate two things, my lord.
Yes.
My lord, kindly turn page number 132, my lord. What learned senior friend, my lord, says that none of the in Group C, Group D category, none of the counseling is held after expiry of the panel. Entry 9, date of publication of final panel, 2012-2017. Panel expired on 2012-2018. Now, my lord,
Was
18 May
it-
2019.
Was it extended? Was the life of the panel extended?
never be.
Because page 132, the second
Yes,
last-
entry never be. It never. That's the was argument
Alright.
for the and
all right, I'll
and
see.
in each and every column they say so, and that was not accepted by the apex court. That is para 30 and 31.
The petitioners participated in the
My lord, a new argument has been made. Kindly see the rule. Earlier rule of 17.
uh,
2009.
the recruitment process for
My
appointment
lord,
as
my lord.
non-teaching staff. Stop. They challenge.
17.
They challenge the
My lord, kindly see the rules.
bracket
6
open
months time I was there in the to extend.
for appointment to the posts of non-teaching staff bracket close rules, 2025. Stop. The the petitioners also pray for an interim order directing the commission to publish the list of the candidates called for counseling in the earlier selection process conducted by the commission in the year 2016. Stop. Paragraph. The matter will be decided upon exchange of affidavits. Stop. Released for further consideration on 14th January 2026. Stop. All pleadings must be concluded prior to the adjourned date. Stop. The interim order that the petitioner is praying is being refused at this stage.
Grateful, my lord.
Service is taken on record and the deficit court fee is also taken on record. Yes, next.
Breaking it.
Lord, 9 I am for the petitioner, my lord.
Already E1909, I am for the state respondents led by Mr. Vaishnav, who is in virtual mode.
My lord, this is my application for a direction upon the board, my lord, for changing my name to Jagannath to Shubhojit, my lord. On the last occasion, your lordship directed the board to file a report. Considering my gazette notification, my lord.
My report, your lordship. In copy, reported copy. এটা ফেরত দিয়ে দিন।
কোর্টকে অত বড় দিন আমাদের এইটুকু
Yes. What
Oh,
does the
sorry,
report
Peter.
say?
My lord, kindly. My lord, may I? My lord, the petitioner, my lord, kindly may I read from paragraph number 3 of the report, your lordship. The petitioner registered himself as Jagannath Mitra with board and passed Madhyamik in 1994. Thereafter, my lord, senior secondary in 2012. Thereafter, he obtained some degree from the primary teaching institution and thereafter joined as a primary teacher in 2017. Now, my lord, passed Madhyamik in 1994 and he came up, he obtained all his service and all his certificates in the name of Jagannath Mitra. Now, in 2020, he made an application for change of name. Now, my lord, what I want to highlight before your lordship, my lord, paragraph 4. I state that petitioner declared his changed name as Shubhajit Mitra from Jagannath Mitra and got notified the same through the Gazette of India dated 2020. The said notification states that changed my name and shall hereafter be known as Shubhajit Mitra. That is in the Gazette notification, my lord, I have had it. So, hereafter, that is on and from 2020, January 2020, he will become Shubhajit Mitra. It has got no retrospective effect. When he registered, and your lordship, when he was born, his birth certificate, it is Jagannath Mitra.
Yes, yes.
Well,
it's all
my
right.
only contention, my only submission is, big lordship, that board is an authority who only holds examination, examination in the state of West Bengal. Board is not the authority to change the name or identity of any person. Well, it is only civil court, my lord.
Please wait.
My lord, this
Yes.
issue has come up before the Honorable Supreme Court in various high courts, my lord. There are at least half a dozen judgments.
Please show.
Yes, my lord.
What are the benefits that you want to obtain by changing your name?
Well, it is my fundamental right. If the changing of name is a fundamental right guaranteed under Article 19(1) and 21. So, my lord, this has been enunciated by Supreme Court also, various high courts also, and those were also the board denied, and there was direction. Specific, if your lordship kindly comes to paragraph 171.
What you want? What is the benefit that you want to obtain? Are you retired or still in service?
In service, my lord.
You are still in service.
Still in service.
Oh, 46
Because the
years.
problem is this, my lord, I have changed all the PAN card, Aadhaar card, everything. From the next financial year, I cannot file the return also. My salary won't come. My salary would be coming in the old name and my name has changed. Everything is there. So this is a predicament, my lord. For the
Creating my service file.
The service file is there, my lord. Everything has to be changed. So after Gazette notification, after the public documents, as per Evidence Act, my lord, your lordship knows that the presumptive value of those documents. On the basis of that, everything has been done. Now the board cannot say on this flimsy and these grounds, flimsy grounds that no, these are absolutely technical grounds they are saying.
Well, my submission
And
is lordship.
exactly pat on the point, the judgments are there, my
Which portion?
Madam, my submission
lordship
is
kindly comes to
change.
What submission? Which paragraph?
Your lordship will kindly come to paragraph 171, my lord.
Copy দিন। Judgmental copy দিলেন lordship?
Reported, right?
না দিলে কি করে বুঝবো?
বলুন।
আপনি কি দেখাচ্ছেন আমি
171.
Yes, my lord.
দেখি,
2021 7
একটা copy
SCC
দিতে পারছেন?
ওই 100 পাতা কি করে কত করবে? 2021 volume 7 SCC page 535.
বার কর না, কে বার? 530?
5. Para 171. Jidya Jadhav versus CBSE.
বের কর। আছে কিনা দেখ। প্যারাগ্রাফ কত? প্যারাগ্রাফ কত বললেন?
171 বলে।
Which portion do you want to rely on?
Entire para 171 বলে।
171 is a big paragraph. You say which portion?
বার করে দিন।
There are two
সেটা দেখা।
categories in
There are
171.
two categories. One is correction and second is changing of name. The second part, my lord.
You want the second one,
Yes, ma'am.
right?
Yes, ma'am.
That means you acquire the name by choice.
Yes.
Right. In the latter category, it says
Yes.
that the request may be entertained upon insisting for prior permission,
Yes.
declaration by the court of law.
Yes.
The affidavit we have done.
No, that is
Affidavit is
That's declaration, my lord.
no.
Declaration before the first class.
Civil
judgment.
court. Before
Declaration-
civil court.
Are-
Obtain an order from civil court.
Fresh certificate in other situations.
Yes.
We have sweared an affidavit before the first class magistrate. That's a declaration, my lord.
No.
Thereafter, Gazette notification.
Listen, had you not been in service,
Yes.
this would not have mattered. Since you are in service, all your service benefits are related to your name, to your identity.
Yes, madam.
And in the midst of the service career, you just think of changing your name. And without
That's
thinking,
subject to correction, madam. That's my right. I can change any time.
very well, you change your name. The court is not directing
No,
the authority. You change your name to whatever name you wish. It's your choice. It's your fundamental right.
Yes.
And the board is not there, or the Article 12 authorities are not there only to go on changing their records only because you thought of adopting a new name.
Madam, not on that. Madam, your lordship will kindly
Well,
come
you
to
have
the
to file
later portion of
declaration
171, madam.
and obtain an order from the civil court, and by that order, my lord, a direction upon the he has to get his birth certificate changed, and thereafter only board can change.
71.
171 lower portion.
I read it. I have expressed my mind as to how I read it. Declaration by a court of law does not mean filing an affidavit.
Yes.
Declaration subject to
When
correction.
Declaration suit.
in an affidavit, you declare, yes, I such and such declare my father's name is such, my age is such, my address is such. This is not. Can that be treated to be a declaration? In that case, let the matter be heard.
Let it be heard, my lord. I shall produce all the judgments, my lord. I have at least 7, 8 judgments, my lord. I will show before your lordship. And even in 2025, my lord, there is another judgment of the Jammu Kashmir High Court considering all these judgments.
Please show. You handed over the most voluminous one.
Yes, that's.
জম্মু হাইকোর্টে কি বললেন?
হ্যাঁ, বলে দিচ্ছি।
2025 SCC online.
Online JNK
JK
937.
2025.
Which portion?
My lord, paragraph 14, paragraph 19. And if your lordship, my lord, if your lordship's desire is that we should have a proper declaration from the civil court, then your lordship will kindly grant us liberty so that we can get a declaration from the civil court and then approach.
হ্যাঁ, ওটাই তো, that is the procedure of an obtained civil court.
লর্ড সাহেব বললে নিশ্চয়ই যাবো, কেন যাবো না? সব পড়েছি।
লিবার্টির দরকার নেই, নিজেই করতে হবে, জাস্ট লিবার্টি দেওয়ার কি আছে?
আমি জজ সাহেবের লিবার্টি নিয়ে করি।
হ্যাঁ, ঠিক কথা। খুঁজে পেলি? এই জাজমেন্টটা দেখে আসবো পরের দিন। এসএসসি অনলাইন লিখেছিস? জীবনে খুঁজে পাবি না, এসএসসি অনলাইন লেখ। উফ, এখানে অনলাইনটা লেখ। আসবে না আমার, এতে গিয়ে দেখ, আমাদের indiakanun.com এর হোক, তোকে এটা মেরে দেখ আসছে কিনা, indiakanun.com। থেকে মেয়ে হয়ে যাচ্ছে, মেয়ে থেকে ছেলে হয়ে যাচ্ছে, যা খুশি হয়ে যাচ্ছে।
এসসিসিটা নিয়ে আসলে ভালো হতো, এটা লাইভ লটা চলে আসছে তো।
বুঝছেন?
Paragraph 172, the Supreme Court exercised its plenary jurisdiction to pass this order.
But
So
then,
you have to keep this in mind.
but that has been followed by the High Courts, my lord.
Well, my only submission is, Your Lordship, I am not the competent authority to change the name or identity of a person, my lord. He has to, first, Your Lordship, admission in the register of the school and board has been done on basis of the
Check
birth
this order.
certificate.
Please
Lordship.
come. Report filed by the West Bengal Board. Report on affidavit filed by the West Bengal Board of Secondary Education in court today is taken on record. The matter has to be decided. Stop. List on 9th January 2026. It will be open for the petitioner to file exception to the report prior to the adjourned date.
Right.
Take this back.
I'm grateful.
Jammu Kashmir, you've taken note of it?
Lordship, on 2025 SCC online.
Of these.
Yes, next.
9.
I'm grateful, Lord.
Haklo. Really?
11. 11 or 10?
Your Lordship,
10. Please come. 10.
this is in relation to Millard, a teacher Millard, who was Millard convicted by a court of law, and Millard page 30 and 89. Your Lordship's last order, Millard, your Lordship was kind enough to direct the state authority Millard to file a report indicating that the admissible dues.
My
As-
lord, it's a report, my lord.
A given copy?
Yes, I'm serving, my lord.
Millard, my client,
To serve in advance, he doesn't get to know what is there in your report.
My lord,
What are you supporting the petitioner?
my lord, area claim, what is the grievance of the petitioner, my lord, already
Allowed?
come to the para 3, my lord.
Yes. Give a copy. Go through paragraph 3.
yes, Millard,
Timely submitted the area claim and already be dispersed in favor of the petitioner on,
2017.
yes, my lord. And the
Millard,
bill number is submitted in.
my
annex
instruction,
also.
Millard, I have, my junior had a talk with Millard, with the junior advocate record. She was instructed to submit that Millard, that is in her specific instruction, my client did not receive this benefit. And number one, even if Millard assuming not admitting that his statement is correct, Millard, the admissible due, Millard, it ended in the year to 2018. Millard, this was not admittedly released. And Provident Fund also, Millard, the government has no business to touch my Provident Fund unless, because your Lordship knows section 60 creates a bar, Millard,
Paid
of the CBC.
suspension allowance.
My lord, let them take the instruction
You
from
did
the.
not paginate this. Please put a page number. I can see
Yes, my lord.
the
My lord, I'm
paid suspension allowance to the headmaster. And is it by cash? ECS it is. ECS payment.
Electronic.
Yes.
Yes,
it
my
must have
client said,
been.
Millard, admitted due page 30 specifically states, Millard, till 2018. He worked.
Very
Number
well.
one,
This is
point-
only the suspension allowance till 17.
Yes,
For certain period till 17.
my client's instruction to the advocate on record, Millard,
Oh, not even till 17. It is from 1st June 2012 till 5th of July 2014, paid in 17. So not the whole thing.
not the.
What about the rest?
কথাটা শোনো
My
বাবু।
lord,
Are there other bills also? After 14, did you pay anything?
my lord, kindly take the instruction, they kindly take the instruction from that line, my lord.
R1 says 16/2012 to 26/2012, 24/18 2012 to 5/7 2014. It comes around 2,43,157. And Millard, the next page also says, Millard, that is corroborated part 2. It says, Millard, ECS 2017, 2017, 2017. This is possibly the date of payment. This is also corroborated, Millard, 2,43,187. So this is, Millard, is corroborated by the previous one. So I think, Millard, my learned friend, esteemed friend, should take instruction because it is an incomplete one, Millard.
My lord, kindly. take the-
Government has
the
always,
instruction,
Millard,
my lord.
taken this matter very serious, casually.
Senior, my lord,
Detailed report,
yes,
Millard.
my lord.
Listen, your senior will not be able to improve the position. The documents that you have annexed goes to show that subsistence allowance has been paid till 5th of July 2014. The person has expired. No, he's there. Right. Now he has retired or attained the age of superannuation. According to the petitioner, service ended in 2018.
Yes,
So from 14 to 18, where is the subsistence allowance? Your report is...
Kindly make it record, my lord. Kindly, I will come back when another instruction.
No, this has to be in consonance with your lordship's direction, my lord. My lord, I
done
this-
in such peaceful manner.
it is employees' money, my lord. The government has no business to withhold it. It is a kind of an unjust enrichment, my lord. Government cannot take benefit
My
from
lord,
my
my
money.
learned senior will, my lord, doing this matter, my lord, in the point of
My prayer is, my lord,
allow me to further, my lord.
my
instruction
prayer
in
is
learned
page 30, my lord. Your lordship has taken care of this.
Um,
Interim prayer from 14/8/12 to 18/4.
District Inspector of Schools, Secondary Education, Purva Mednipur, signed on 27th November 2025.
তোমার senior কোথায়?
11তে আটকে আছে, চলছে matter ওখানে।
Is taken on record.
পাশের ঘরে
Stop. Copy of the same has been handed over to the learned advocate representing the petitioner in court today. Stop. On a perusal of the report, it appears that subsistence allowance has been paid to the petitioner
My lord তো বলেই যাচ্ছি আমি। My lord,
with effect from 1st June 2012 to 5th July 2014.
আমার সামনে
The petitioner attained the age of superannuation
বলে যা
in
যাওয়ার
the year 2018.
my lord,
Stop.
me and
There is no mention.
বলে যা।
kindly, my lord, permit to leave, my lord. Okay. The next court, my lord, matter reached, my lord.
Your matter is going on here. Nobody is there.
No, my
What is this?
no, my lord, paying apology, my
It
apology.
cannot be done. At least somebody should be here.
My lord, I'm paying apology, my lord, please, I'm interpreting apology. আমি করতে হবে, report দিতে হবে,
Right.
করতে হবে, কি করবো?
There is no mention with regard to the unpaid subsistence allowance.
কিলোলে এরকম হবে আস্তে আস্তে
ঠিক আছে?
ব্যস্ততা থাকলে এরকম হবে।
The
আমি senior আরেক
District Inspector of Schools, Secondary Education, Purva Mednipur is directed to file further report disclosing their stand with regard to the balance arrear payment receivable by the petitioner. The said report shall positively reach the learned advocate for the petitioner by 19th of December 2025. Stop. Release the matter for further consideration on 13th of January 2026.
Deeply obliged, my lord.
Well, kindly come to page 88 for once.
Page
88, the writ petition. There's an impugned order. The similar issue lordship has already decided.
And for the state.
So this is a transfer matter.
Yes, whether when there are two vacancies available, this is the order. Your lordship passed this order.
Yes. Are you aware of this order?
No, not completely, my lord. I was just going
Check, check. Please check.
I have only one copy. I'm sorry. Soft copy.
You have a phone. Check up. 24806 2025.
I'm sending him. I'm sending him.
18th of November
sending.
2025.
আমার কাছে আছে তো ফোন থেকে দিয়ে দিই
Your rank is presently second in the first preferred school, third in the second preferred school, first in the third preferred school. Third preferred school, total enrollment 7,000. Please come.
ওকে ডাকতে হবে বাকিদেরকেও ডেকে ওটা
Commission was directed to revert with instruction as to whether the candidates.
But I have sought for ballot still date ballot I have not received.
Nothing. 17th of November.
Yes, ballot.
Nothing.
The selection process is going on. Everybody is busy in ballot interview and verification. পাঠিয়ে দিছি দেখো না অর্ডারটা পাঠিয়েছি Disposed of.
The petitioner seeks transfer. Stop. The impugned order of the Commission dated 21st June 2023 mentions that her rank is presently at the second position in her first preferred school, comma, third position in the second preferred school, and first position in the third preferred school. Stop. The third preferred school has enrollment of 131 students with total 15 teachers, and no further recommendation can be generated based on the pupil teacher ratio of the school.
May I take your lordship's leave for 1
Yes.
minute? My junior is
The Commission is only left with the second and the third preferred school. Is left with the schools where the petitioner's rank is 2 and 3. Stop paragraph. The learned advocate for the Commission was directed to revert with instruction as to whether the candidates whose name appears in the first and second position in the 2 preferred schools by the petitioner are agreeable to join on transfer. Stop. The Commission has not been able to forward the instruction as sought for. Stop. In view of the above, the Commission is directed to grant an opportunity of hearing to the petitioner and the other candidates whose name appear at the top of the petitioner in the ranking list to ascertain as to whether they are interested to join the vacancy.
This is very difficult for one ascertaining.
Right?
Because one commission has to contact them, they have to call for.
2 candidates.
Yes.
2 candidates, they are wanting transfer.
Yes.
Commission has to act. Commission cannot sit
No,
tight.
they have to be contacted, whether they are willing or not willing.
Obviously, because you have rejected saying that she is second. She is, yes, she is second or third.
Difficulty in the proposed order is that perhaps that was under medical transfer.
No, general transfer.
This is a general transfer. There is no provision in the rules that in case the 3 vacancies opted for, if those are not available, then the petitioner or the applicant should be given the opportunity of.
All right. Suppose your submission is taken to be proper. What do? You sit tight. You find out that the vacancy is still there. You see there are a number of candidates in the panel, but you don't act. You fill up the vacancy.
Yes.
Nothing remains.
Nothing
Yes.
remains.
Your action is, I will not act. Nobody can direct me to act. The law doesn't say so.
That is not. Let me clarify. Since
There is no reason.
suspended, we could not proceed. The actual procedure was the rank was given.
Actual procedure, normal procedure, abnormal procedure.
When the portal was on, the first rank candidate, he or she.
It has been decided by the division bench. Suspension of portal is no ground to withdraw transfer. We cannot take the alibi today. It has been settled by the division bench.
Vacancy, ঠিক আছে? If none is willing to join, then the petitioner may be recommended for joining in the schools preferred
Up to this
by
one,
her. ঠিক আছে? In the event the vacancies are not available, then the petitioner has to apply afresh for uh, a fresh seeking transfer. Stop. A decision shall be taken by the Commission at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. It is made clear that suspension of the Wbslst portal will not be a ground for not processing and proceeding with the application for transfer that is pending at the end of the Commission. Disposed.
My lord, if I further, in case I apply, the state would be same. It will be not be considered. Your lordship has seen.
Other preferred schools will be there.
No, let them show preference to other schools to me as well. Why can't, my lord, again I have to come because your lordship has seen it will not considered by them.
Yes, next.
Item number.
Item number for the petitioner. This is for extension of validity of recommendation in respect of upper primary selection process. This issue is covered by a division.
Pass over on behalf of Dr. Pati, engage before the division bench. Matter
Where
going
is
on.
the junior counsel?
She is assisting Dr. Patri in those
Kindly
matters.
speak just 1 minute.
In that case, please increase your
saying
panel
short
so that
pass over.
others can also come. One matter is going in one court doesn't mean the other courts will not function. It cannot be done. Yes.
Just 1 minute, madam. Kindly see the last order once
Yes.
passed. Madam.
Yes, say what is it?
Yes, my lord. Then, my lord, it is the second round of litigation. My lord, what happened, my lord? Petitioner was a job loser in respect of first SLST. My lord, their job has terminated 9th April. Parallelly, petitioner participate in upper primary selection process. Upper primary selection process counseling was going on in the terms of division bench order in November 2024. Counseling, and accordingly, I participate the counseling. But at that time I was working in the 9-10 level in a separate school. Then my lord, school has been allotted to me. Appointment letter has been issued. At that time I was also working in a 9-10 level. That I chose not to join that school. Subsequently, 3rd April, my job has terminated. Then I made a prayer.
You want your
Yes, my lord.
recommendation
What
to
happened,
be
my lord? They
extended.
as per rule, my lord, a recommendation in upper primary selection process is valid for 90 days. But in their discretion, they can extend further period of more 60 days, but 150 days it is allowed. But my lord, I made a representation before the authority within 150 days. So they can consider it. My lord, first round of litigation, honorable court directed
All
to
right, let
consider.
Dr. Patro come.
Yes, my lord, and division bench, my lord, yesterday, my lord, one of my learned friends shows that there is a division bench judgment that job losing is a special circumstance. They should be accommodated. That is my contention. And my lord, another prayer, my lord, similar.
Let you make
Yes,
the
yes.
submission in front of Dr.
My lord,
Patro.
a similar issue is pending before you let the heart the analogous similar issue. My lord.
Which item?
Yes, 83 to 96. My lord, your lordship. Let
Today's
it be-
list.
Yes, today's list. 83 to 90.
And
One issue, my lord. One matter is here, lord.
1 minute. Similar issue, and is the other side who is here?
Dr. Patra.
Dr. Patro in all the matters.
And my lord, also monthly is 1629 to 1632. That matter I have mentioned, your lordship.
1 minute. 83 to 96 and
1629 monthly is 1629 to 1632. Similar issue, my lord.
1632.
Yes. 1629. Kindly fixed at any day. I will.
1 minute. Please take down the numbers. Today's list.
Yes, 1629 to 1632. All Dr. Patru is appearing.
Let him check.
Yes, yes.
Please see. All right.
Yes.
I'll make it not today.
Yes.
Let tomorrow.
Grateful.
এই নাম্বারগুলো একটু নোট রাখুন।
I'm checking for a not today.
Item 13 not
Yes,
today.
yes, not today.
All right, not today. Item 14.
I appear এটা সব কে ছিল আমাদের শান্তনু মিত্র is appearing on behalf of the council.
Council.
High Secondary Council.
High Secondary Council. What is the issue?
Well, the issue is the reassessment of the ancestry. Although, my lord, there is a, I know they are all judgment against us. My lord,
I'm appearing for the secondary council led by Mr. Shantanu Kumar.
Yes. What is your submission?
Lordship,
let me, your lordships kindly allow me.
Delusion of answer script is not permitted, Lordship.
All right. I'll take it up. It's already 1:15. I'll come and take it up.
Lordship.
At 2 p.m.
Yes.
or Calcutta?
Tomorrow.
Tomorrow?
It is up to you.
No. Can it be possible for tomorrow?
Yes, I'll keep it tomorrow. Not today.
We have affirmed an affidavit in respect of one of these matters, and maybe permitted to file it, item number 19.
Certainly, file it.
19.
Copy দেবে একটা
Copy, sir.
রেখে দাও কপিটা
Get a hard copy here.
Sir, may I come straight to the point? That is,
One minute. This is item 15 going on. It cholche na screen ta? Item 15 going on, and there are cans. You are there in the can.
can number 1. Can number 1. But I'll set to the point. I take the arguments made by my learned friends appearing for the writ petitioner serially and try to give my humble answer to it. The first argument was that the rule of 225 is ultra vires and wholly void. Now, my humble submission, yes, because of arbitrary and all these things already there. But why arbitrary? What is the reason given? Why is arbitrary? Entire rule. Not in the petition, in my submission, a lot of things have been said, but no ground is really made out to say that rule 225 as a whole is bad. See paragraph 12, 9, 10, see the grounds below. This is some views have been expressed. Why it is arbitrary? Or why it is bad?
Yes.
Emphasis in course of argument, emphasis was placed on the clause in the rule giving 10 marks for teaching experience. That has been specifically assailed and grounds have been indicated that I can deal with. I have to deal it one by one. But as a whole, how can it be? That one of the learned counsel for writ petition has cited judgment of Supreme Court. When a rule can be wholly bad, and the judgment says that if the rule is altered by the parent act, then it is void. Altered by the parent act. The judgment has been cited and not by one of my learned colleagues for the writ petition, and not that judgment I have noted, and they set out the grounds of parent act. But in my humble submission, nobody has argued that this rule of 225 is altered by the parent act. In fact, Mr. Bhattacharya has not even placed the parent act as my argument. Now see the parent act and how it is altered by parent act, nobody has given reasons. That is the approach should be for parent act. Altered by entire thing, entire rule. Now, next argument has been that this experience for teachers, giving marks for teachers. 10% mark for teaching experience. That is the point. Let us say Mr. Bhattacharya has argued that it is a malice in law. There should be pleading of malice in law. Malice has to be pleaded very carefully. A statutory provision is being said to be malice in law when it can be said. Statutory provisions. Because in my humble sermon, that is not the ground and said Schedule 2 experience under void appointments should not be that's I can understand. Argument made that experience, teaching experience for gathered by those untainted candidates whose appointments were void. So therefore, the appointment void, therefore experience they have derived as a that should be also not be considered. That's the argument. Let me deal with that point, one specific point, at least I've argued. First, similar, kindly see the schedule 2. That first similar is a thing that qualification marks, teaching mark, is not confined to the untainted teachers who had served under their void appointment. It is not, the rule is not confined to the government schools of West Bengal. That is very important. Can you schedule 2? Schedule 2 of the rules. Schedule 2, Milord, at page 11. Start teaching experience 10 marks. See the language, Milord. Similar, I'm reading at the secondary, prior teaching experience 10 marks, at the secondary level, in a government or government aided or government sponsored school, not in West Bengal. Any government sponsored school, central, that is a central government. Schools are there. If they have derived some experience in from the central government school, or let's say Bihar government school, they'll all be eligible under this.
But then it's just to inform you that the commission did not treat the experience of candidates from other states, right?
No,
They had to
that
come
is the
to
point, Vishnu. Calcutta ascertain an application was made by the central government teachers, employees, before our division bench.
So they had to come to court to obtain an
Yes,
order, not that the commission granted it suo moto, relying on the rule.
What happened is this: the government central said we are also entitled to. Then what the division bench ordered, you make a representation to the commission. Let us see what they say. I am given to understand that the commission can correct me. Commission did not say that non-state government employees' experience is not to be counted, but they were counted out because they didn't have permanent substantive post.
That is different.
Therefore, my lord,
that is different.
I humbly submit this rule, if commission construed wrongly in my submission, is not confined to all government aided school in West Bengal. It's not confined to West Bengal. Then this argument is based on a factual assumption which is not correct. Rule does not say so. But if the commission, as my lord said, commission think otherwise, then question will arise whether commission's understanding of rule is correct or not. If the commission thought that is confined to only state of West Bengal, I say it's a wrong thought. Wrong thought. It goes against the rule. And if I may say, commission should be allowed to act, to go against the rule and make up argument accordingly. So, there is no factual basis for this argument. We have to read the rule as it is. Commission is yet to argue, but commission's opinion is not binding on anybody. If they, but I've not seen the affidavit. I do not know where they have said that is confined to only West Bengal government schools. I have no affidavit, nothing has been given. I do not say where they have. I request your lordship to read the lead
All right.
as it
all
is.
right.
Therefore, my submission is not confined to West Bengal government. In central government employees, lordship, when the commission argued, ask them what was the reaction
All right. All right.
when
Next.
the government employees. Yes. Now, on this basis, the argument is based that only state government employees' experience will be relevant. It's not factually not correct. Rule do not say so.
All right. Next.
Yes. Therefore, let us now consider on this basis that of my submission that experience gathered by all government aided sponsored schools in a substantive post as permanent or on contractual basis. Must be substantive post.
What does this mean?
Does not they say so? Substantive post, not a temporary post. I am given to understand, by commission correct me, central government employees application or representation for getting the 10 marks were rejected on the basis that none of them held substantive posts.
What, according to you, is a substantive post?
No, which is permanent, not temporary.
So mere permanence should be there.
With a permanent appointed substantive post, must have, which is not maybe contractual, but permanent as permanent or contract. Bracket says so. Substantive post means as permanent or on contractual basis.
Right.
A permanent or contractual basis. That's the definition they have given. We have to go by the rules. Rules, unless it is declared to be ultra vires, clause, is binding on the commission, on everybody. And even Millard, we have to say that we have to act according to rules. Therefore, not substantive post as permanent or contractual basis. Now, Millard, it was expected, Millard, the person or authority person who assail a rule or action, statutory rules presumed to be valid. Onus is on them. Now, as my lord asked me, may I also humbly submit that nothing has been clarified in that argument what is meant by substantive post. They have not said that these untainted employees did not hold substantive post. This is why I'm emphasizing. They say the substantive experience gathered by them as a teacher was under a void appointment. Am I right? So, but this is one argument, legal argument. But the teachers did not hold substantive post. That is not the argument of anybody. So, Lord, if I can satisfy Lordship that even experience or any benefit gathered under a void contract of employment, that can be detained by the concerned employee provided he was the innocent party. He was not party to the illegality. This is under law of contract. Supreme Court specifically given, but Supreme Court has not given an illegal order, passed an illegal order. My submission would be, answer is number one answer, this question is no longer open because order of some Supreme Court in Boishagil matter is binding and final and binding. Let us see the order. Supreme Court says, see the order, my lord, the conclusion part. First part is tainted. similar Supreme Court making a classification between tainted and untainted. That classification was not made by our High Court division bench. That classification was not made. All and sundry was cancelled. But Supreme Court made this modification. And Supreme Court made a classification between tainted and untainted, two groups. And this classification as made by Supreme Court cannot be challenged. This is an order and final. And the Supreme Court has made discrimination, how do you call it, differentiation, between tainted and untainted. Now let's see what tainted, they are not entitled to receive benefit of the services they have rendered. Similar, the tainted people, they had contract employment like everybody else, and they render service as a teacher. Question is, why Supreme Court deprived them of the service they have rendered, or the benefit of service, like it said, remuneration, namely service experience, everything. Supreme Court clearly says, can now see me lot. The last we find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates, High Court has all candidates really, were appointed must be terminated, and they should be required to refund any salary payments received, since their appointments were a result of fraud. This is important, my lord. Fraud to which these tainted employees are parties. This is what is the instance of tainted candidates? They submitted blank answer papers and got appointment. They knew party to the fraud. No answer given, but they got the appointment. The 4 instances appointed here. The party to the fraud, result of fraud. This fraud is mutual fraud. Commission and the tainted candidates in conjunction has committed the fraud. In case of untainted, they are not party to this fraud. They are innocent parties, victim of circumstances. And Supreme Court making this clear distinction, result of fraud, they will not. This amount, therefore, to see no justice. Therefore, they cannot retain the remuneration even. Now, say in the case of other class, for candidate not specifically found to be tainted, the entire selection process has been rightly declared null and void. High Court declared. And High Court really didn't make a distinction. High Court, the entire process null and void, and all appointments are invalid, void. Said so. But Supreme Court now could make a modification of High Court's order. Due to aggregation, violation, and litigation, illegalities, which violates Article 14 and 16 of the Constitution. As such, appointment of these candidates are cancelled. They are being cancelled. Their appointments are cancelled. Appointments are not declared void. If appointments are void, they don't have to be cancelled. See the language, very clearly distinctive language. So the practice was found the entire process of selection process was null and void. Therefore, result is their appointment become voidable, and Supreme Court cancelling it. It clearly indicates that Supreme Court did not consider the appointments to be void, because Supreme Court is conscious of a fact that if a party is not an innocent party to a contract, is not to be punished. Principle of pari delicto. It's the law of contract. Ex tarpai causa. This is law of contract. What is that? It's a contract of employment between a teacher and the commission. The contract is contained in the appointment letter. It's a contract employment. And pursuant that contract employment, everybody served for the period allowed, right, because of delay in the matter. But their two groups are different. One group is serving knowing that their appointments they have been fraudulent, party to the fraud. Other group is serving on the basis that, and if I say legitimate expectation, that state actions are honest and valid. Let one Mike.
Nothing to do with this case, nothing to do with this case. It is for you. Mr. Mitro argued in that 33,000 matter. In fact, all of us, Advocate General, we, just a judgment has been delivered. 33,000 teachers, their services are protected.
I'm very happy.
That's I thought.
Yeah, good day,
Mr. Mitro also appeared. I also appeared.
We all appeared. Today, আজকে এসে বলছিল order জন্য কি হয়. But I was sunset after my argument, nobody consulted me. Take it. And I'm very happy because 30,000 primary, that is primary education. Now, may I go on with this, Milord? Primary. Milord, there's a, apart from the Supreme Court order, I don't have to should not argue more. But it has been argued, that's why I have to give a reply. These were cancelled. The next line, however, the candidates who are already employed need not be asked to refund or restitute any payments made to them. Benefits under their appointment are being allowed to be retained, which cannot be done in case of fraud. It can be done only under a contract which is cancelled, but both the contracting parties are not fraudulent. There's one innocent party, and commission definitely is a party at wrong party. The employer. Definitely, no. So, Milord, this is being retained. This cannot be challenged by anybody. Final. Therefore, Milord, in my humble submission, the selection process may be null and void. But appointments, contract of appointments of employment entered into by the commission and the employee teacher is different footing. It will be voidable if discovered to be void later on. Also, side judgment necessary that two things are here. One is, Lordship knows the theory of quantum merit. I deserve as I deserve. So, if a service has been rendered, there is no allegation, at least no argument anywhere, that those untainted candidates did not teach properly their delegation duty. Students were not benefited by their teaching. Their performance under the contract, which is being cancelled after 7 years, their performance is not below standard. This is one instance, Milord, where Supreme Court completely. However, see, their service will be terminated. Service will be terminated. Terminated, not void. It was voidable at option under order of court. A selection process declared void, but appointment made thereunder not declared void by the Supreme Court. It is cancelled by the court. It is terminated by the court. They must similar. Furthermore, no candidate can be appointed once the entire exam process results have been declared void. No candidate appointment once. Therefore, appointment cannot continue. Appointment must be terminated, must be brought to an end. Because the result has been declared void. That should be clear. So appointment must come to an end. And it is being brought to an end by an order of court. Not void, null and void, no void from the inception. That was similar next, thereafter, see the next paragraph. Other benefits retained by the teachers, I mean untainted teachers, are being allowed to be detained. Kindly similar paragraph 47. Sorry, clause 47. Yes, 47. Some appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with the autonomous bodies, etc.
But this paragraph will not be relevant in this case.
Please see, my lord. Just 1 minute more. Although their appointments are cancelled, these candidates who have the right to apply to the previous departments or autonomous bodies to continue in service with their entities. These applicant must, their applications must be processed by the respective government department or bodies within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of the previous appointment and the rejoining will not be considered a break in service. This is important.
No, this is not for you.
Lordship, considering order of court. Question is whether the benefit of that service made under the contract which later terminated has been allowed to be retained by untainted. And this benefit allowed to be retained. Why not experience it? Why not experience it? And this tainted people, they are being allowed to retain their experience. Their service is being continued, not a break. This is very important. The tainted employees, some of them had served previously, maybe government, other government institutions, independent bodies, etc. And they gave up that and joined this West Bengal school services. Supreme Court is very clearly saying, this is important, my lord, the period between termination of their previous appointment and the rejoining will not be considered a break. Then their seniority and other entitlements will be preserved and they will be eligible for increments. This is a sign of saying called treating null and void. Being allowed specifically. Here it doesn't matter whether I am appearing for any of the employees or not. I'm appearing for the untainted employees. Untainted employees. What has been Supreme Court intention is clear that untainted teachers will be allowed to retain the benefit of their period of service, including the period, their seniority, and their entitlements will be considered as if they had continued in the service of the old employer. What does it mean?
That means the old employer.
Yes. Will continue them.
Old employer, you were not in old employment. You are not at par with this.
I appreciate. Correct. Old employers will do it.
Yes, that means
the previous. Why the old employers were allowed to do it? Why the old employer cannot say you are under void employment? I shall not give you. Void employer, I shall not give you the benefit of resumption, continuation. But it is not. I am asking for this. I am order of Supreme Court has to read as a whole. There is no question of anybody else. If you read the order as a whole, then Supreme Court is expressly allowing those untainted candidates who had given up other employments to rejoin their service. Number one, very good. And to retain the benefit of serving in the school of the West Bengal government, period of 5 years, 6 years maybe. They're allowing tainted candidates, are being allowed to retain benefits. 1 minute, 1 minute. 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 of the period of service under government. Benefits were seniority, one of them. The seniority will remain. Although, how can it be then? Appointment is void. Appointment void, that how the seniority could be retained? Therefore, all that I'm saying, this all indicates that Supreme Court did not consider or did not hold the appointments were null and void. That's what important point I'm bringing to. If appointments are null and void, patented, then regardless of whether the government employees came from another government institution or not, would be irrelevant. If those tainted employees who came from in the independent institutions are being expressly allowed by Supreme Court to get the benefit of the seniority
All right,
of
I
the
got it.
period of service.
Next point, please.
This is Milord. Next paragraph. Another paragraph which clearly says another thing. Paragraph 49. Disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation even. Age relaxation, I'm emphasizing on this. Age relaxation will be allowed.
That has been allowed.
Yes, it
has
I'm
been allowed.
emphasizing on that.
Right, it has been allowed.
That's Supreme Court allowed that. What that indicates, therefore, Supreme Court says, Supreme Court is paying the full weightage. Supreme Court is giving full weightage to the service rendered by the untainted candidates, to their period of service under so-called cancel appointment. I'm on the Supreme Court, weightage is being given. And then why not teaching experience? That's also an advantage. Now, argument is, therefore, the selection process was null and void. Therefore, teaching experience is also null and void. See the logical legality of this argument, logic of this argument. Is there any logic behind this? If they're null and void, then they should not get any service, employment. They should not get any salary. They should not get advantage of their seniority. They should not get any advantage to appear again. They should not get age relaxation. They should not get age relaxation. These three things, cannot be given. This benefit cannot be given unless Supreme Court decided and clearly decided, intend to decide that weightage should be given to the period of service rendered by these untainted employees. And this is said very clearly by saying, retain your remuneration, retain your seniority, if you are coming from another thing, and there will be age relaxation for you for the period of 5 years, 6 years you have spent when you are appearing in real service again. This opportunity, eligibility to appear in the first selection process is not given to tainted employees. Not to tainted employees, but given only to untainted. So a clear classification is made that there's a difference between tainted and untainted employees. And this is the order. Kindly read paragraph 51 also. Accordingly, we uphold the impugned judgment, cancelling en bloc entire selection process. What is selection process is cancelled en bloc, but have made certain modifications in the direction issued by the High Court. That means selection process cancelled, but modification is made in the direction of High Court. Therefore, my lord, our division bench, when faced with a contempt application, they said, my order is merged in the order of Supreme Court. Therefore, to go to Supreme Court for contempt of court. Yes, this paragraph 51 modification means order of division bench of High Court merged in the order of Supreme Court. Order of division has no existence now, no independent existence now. Yeah, we have whatever see this final order. That means you may refer to for any purposes, but what you like.
Refer to where?
You don't refer to this order of division, High Court order, for asserting the rights of the people, ascertaining the rights of the tented and untented teachers.
I didn't get it.
My lord?
I didn't get it.
No, because order of High Court has no march in the order of Supreme Court.
Yes.
This is the only order I have to see and determine the rights. The rights. Whatever High Court has said. Yes. But that has been modified by the Supreme Court. So, my lord, I am referring to it because, my lord, I found my learned friends or petitioners were reading substantially from Justice Division Bench order of the High Court.
Yes.
Why they are reading it? I am objecting to that, saying that that is not there. It is not the Supreme Court order. Read the Supreme Court order.
Yes.
Supreme Court judgment and say whatever you want to say.
All right.
But not the reading from High Court order, which has merged.
Yes.
Has no separate existence now. That is why I pointing out to Lordship. I am answering the argument made the other side. My lord is right. That should not have been argued at all. That should not have been argued on the basis of the division judgment of the High Court.
Yes.
Yes, Lordship might have stopped them. But not allowed to argue, therefore I am giving a reply. Today I am giving a reply point by point. So, my lord, now let us come to the point. What is the then basis for the argument that teaching experience gathered by those untainted candidates during the tenure of service under the school should not be given?
Since you are referring to the Supreme Court order,
My lord, yes, my lord.
please also refer to the order of 17th April 25 passed by the Supreme Court.
Yes, that's right.
Please come to that order also.
Division bench order, my lord.
Supreme Court's order.
Yes, I'm holding it, my lord.
17th April 25 order.
Which paragraph, my lord?
Page 108. In the writ petition, I can see.
Separate order, another order, no?
Yes, it's a separate order.
Separate order, I see. Then let me close this. Yeah. Yes, my lord. Order dated? Order dated?
17th April.
17th April. Yes, I've got it, my lord. I've got it, my lord. We inclined to accept the prayer. That's how it begins.
Yes.
We inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9, 10, 11, 12, not found to be tainted, subject to the following conditions.
That means you fall in this category?
What?
You fall in this category?
Yes, this is found to be not tainted. Accept the prayer. Prayer, what made one application was, he prayer made curriculum. Yes, that's right. And
so you fall under this category?
Yes.
You are not found to be tainted?
Yes.
Right?
Correct.
Please come to that order at after paragraph 4 in the next page.
Yes, my lord. 4.
We clarify that.
We clarify that. This order shall not be read as conferring any special right or advantage on the aforesaid teachers, insofar as fresh recruitment process is concerned. Correct?
What does this
Correct.
mean?
No, that's why I am not saying that this order, I am confined. I said the order in Vaishali's case had conferred some advantage and right on the untainted. I'm confined. My argument is this. I am blessed with Lordship. Under the order in Vaishali's case, but some advantage and rights have been conferred on the untainted candidates. And those rights have not to be interfered with. I am not asking for any further right under further orders of court. Supreme Court has lastly said the order of Boishal is final. And I am confining my argument to the rights and benefits conferred by that order, not by this order. Let's go in. Let's go into so far as concerned, no special advantage. With these rights, whatever has been conferred by the Boishali judgment,
This is in the same matter.
with all the rights and benefits that have been conferred upon us by the Boishali judgment, we shall participate in the fresh selection process.
Yes.
This is the point. With whatever rights and benefits conferred upon us by the Boishali judgment, with those rights and benefits, we shall participate in the selection process. We will not divorce the rights and benefits conferred by the selection process. The argument is entirely on the basis, on the friend we must respect, that as if we shall participate in the selection process, divorce the benefits and rights conferred by Boishali judgment. It is not Supreme Court query in so far as this is the point. This is the fallacy in the argument with respect that the rights and benefits, with those rights and benefits, we shall participate in the fresh recruitment process, not divorce those rights. And one of those rights is the benefit of the service you have rendered, including everything, and which include experience and seniority and teaching experience gathered. That will be gathered. So, my lord, point is that our service as untainted teachers, the rights and benefits conferred by Supreme Court, that's why I am placing that order. They have given the right of retention of the financial benefit. Supreme Court giving the right of retention of financial benefit. They are giving the right of retention of the seniority benefit as and when necessary for those, as when necessary for seniority benefit. They are giving the benefit of age relaxation for those who want to participate in the fresh selection process. Similar in the fresh selection process, the freshers will come with particular age qualification. But this group, untainted, will have higher age, older age, they will be allowed to participate. Similar, this is a class by itself Supreme Court has created, and there is no classification within that classification. Well, I am only saying, kindly see, as Supreme Court has said later on in a judgment order, I find, the rights of the untainted should be preserved. Now, my lord, lordship has been shown the last but one order, order dated 23rd November, no? 26th November. Which means the Supreme Court, he said the court of first instance, let them decide. Because it is very orthodox approach by Supreme Court.
Should not have been.
Orthodox approach.
Should have been.
I am happy.
No, this orthodox approach should not have been by the court.
No, that is not. I'm not saying that. But it was orthodox approach, Lord, because the court, usually appeal court always said that's the benefit of the first court. You will also sitting in division will say that's the benefit of first court. Supreme Court saying, let me have a benefit of the views of first court, who will go into the facts of the matter more deeply than appeal court would. So Supreme Court said, let the first court decide, we shall have benefit of it, then matter comes up, we shall enjoy that benefit. But Supreme Court did not want to deprive himself of the benefit of the wisdom of the first court. And please see the last paragraph, last page. It's very important. The Supreme Court has said, I'm very happy and proud of our High Court. They have reposed so much of confidence in the High Court. The High Court shall examine the matter uninfluenced by any of the observations or merits made by this court in the orders passed after decision in Boishali charge. Whatever observation made on merits, etc., and Boishali that High Court will not touch. But not High Court, High Court, Supreme Court is reposing so much of confidence. I'm happy. Calcutta High Court, after a long time, is gaining some importance that by any observation made for a court. That shows the degree of confidence the Supreme Court is reposing in the High Court. That I'm proud of that. The next paragraph. The High Court shall also be mindful of the fact that untainted candidates in the past selection were allowed to sit for the selection tests to be held afresh, and their candidature cannot be adversely affected by application of the new rules. New rules should not be construed in a manner which would adversely affect them. This is not humbly pointing out. Supreme Court is merely clearly making a classification, and Supreme Court sympathies for the untainted candidates are apparent. What does this mean? That the effect and candidates cannot adversely affect the application of new rules. That is, West Bengal, the school rules is mentioned 2025. So, my lord, while construing the rule and applying it to the candidates, please ensure that the 10 untainted candidates, their rights which have been given by the Supreme Court under the order of Boishali judgment, and their selection test allowed to sit is not adversely affected by the new rule. It does not, what does it mean? It may understand it as I have understood. Even the commission, by making new rules, cannot take away the rights and benefits which have been given to the untainted candidates by the order in the Boishali case. It is clear. If the commission has made any rules which will adversely affect the rights and benefits given to the untainted candidates by Supreme Court in Boishali judgment, then the rule will not valid, could not adversely affect. Even the commission making rules cannot adversely affect that right and advantage given. So, my lord, while discussing the validity, legality of the rules, kindly bear in mind this interpretation about Supreme Court. Ensure that no right given by the Supreme Court by the order of Boishali's case can be adversely affected even by the new rules. New rules has to be read in that fashion, in that manner. May I place a
Yes,
judgment regarding contractual fee? The innocent party is not affected by if the contract has become void.
Will it be required? I don't think it will be required. Now it is up to you what to
This
cite
innocent
and not
party
to
is not
cite.
to be affected by termination of contract.
It is up to you. I will not stop anybody from making any submission because
Well, I get the proposition given lordship.
right.
I judgment cite later on.
It is up to you, sir. I won't stop you.
1968 Supreme Court case that I am relying on All India Reporter, 1968 Supreme Court, 1165. at page 1176. 11 at page 1176. এটা আমার বইটা দাও, তোমার তো পেজ মিলবে না তো, তুমি এসসি লিখে হবে, আমার বইটা দাও, পেজ মিলবে না। Losses have been given. Well, I have read from my reported AIR. What the page bolu? 1176. 86 district to 86 na 68. AIR 1968 Supreme Court. 1165 at 1170. The continuation of my paragraph. 11. Sorry, Milord, delay হয়ে যাচ্ছে। বুঝবে তোমার বই ফেরত দিয়ে দিই, নিয়ে নিচ্ছ তো? বলুন ছিল কি, কোথায় গেল লোকগুলো, কোথায় গেল বইগুলো? বাদ করে দিন। 1968 সুপ্রিম কোর্ট প্যারাগ্রাফ কোথায় মিলবো? আচ্ছা বইটা খুলে বাদ করে, better will not waste my lord's time. Cite this judgment later on. When will later on বাদ করে রাখবে, প্যারাগ্রাফ নম্বর থাকে না, অন্য জিনিস। Now, my lord, may I now deal with the argument that mark 10% marks given to teachers of government schools is bad. That is the main thing. I'm using expression government schools because the rules do not say West Bengal government schools. Rules do not say that. No. What are the grounds are good, and I will deal with that right now. What is the test for determining? It is said to be altered by this arbitrary Article 14. But what is test for determining the marking process? This is not eligibility criteria. Anybody can come. One need not have teaching experience for making application. The gate is open to all candidates, whoever. There is no restriction on that aspect. It is regarding marking of the merits, marking. And that may not be done, it is declared beforehand. The rule of the game has not been changed. That was declared beforehand. Those who apply for this post, they are expressly told that this is governed by the rules of 2025. And they know very well that those who have teaching experience of government schools will get an extra 20 marks, 10 marks, 10% mark. With knowledge of that, everybody has joined, including candidates who do not have any teaching experience, and candidates who have teaching experience. This is transparent, nothing clandestine. Now, with this knowledge, they are participating. Everybody participated. Now, what is the test for deciding? Well, I'm hard, arbitrary many times, unreasonable many times. But what test for determining this? Not mean a humble submission. The test is that this marking system, what we marking, should have a reasonable nexus with the object and purpose of the rule. So Lordship should have been addressed, showing what is the object and purpose of the rules. And then lordship should have been addressed that this is the object and purpose. And the 10 marks for teaching experience has no nexus with that object. With utmost respect to all my learned friends, they have not argued on this, they have not touched on this aspect. But this is the fundamental rule of declaring anything a violation of Article 14. Any condition imposed which has no reasonable nexus with the object, that is arbitrary, not anything.
Yes.
Now, my lord, in a system, lordship has seen in tender matters mainly, lot of conditions are given that you come, but those who have financial capacity of more than 6 crores will get this additional advantage. Those who have supplied similar goods to other government companies, they will have this additional advantage. That is not eligibility criteria, but additional advantage. No court has held that to be invalid or illegal unless it was shown to the court that 6 crores financial capital has no nexus with the object of the notice. If the suppose is a contract for value of 50 lakhs and the condition imposed must have 6 lakhs, then that will be struck down, no doubt. So case is reasonable nexus with the object. Now, what is the object of this rule? These rules framed under section 17 and 8 of the Act. Please see this Act below. Although they have not argued, I am arguing this point. তো তো argument করেনি point এরকম তুই বলেছে নেক্সাস নেই বলে argument করেছে কেউ অনিল লাইড এখন ফোন করে জানাচ্ছে অর্ডার হয়েছে অর্ডার দিয়ে ফেলে রেখে দাও তেরি মুশকিল করছে এখন আর্গু করছি রেখে দাও থামছে ওটা বোর্ডগুলো থামে না হ্যাঁ that section 8 I'm drawing my attention to because in that rule it is mentioned exercise of powers given as 8 and 17 both 8 below section 8
Is it annexed anywhere?
of the act of the parent act
Yes, is it annexed?
Dr. Guruswami's compilation.
বলে দাও up
Up
to
the compilation submitted on the other day by Dr. Guruswami.
কোথায় পাবে এটা ওয়েস্ট বেঙ্গল কোথায় পাবে একটু বলে তো এটা কোথেকে এইটা তো
Is the matter in the list today?
Yes, my lord.
Which item?
Everything is running. Item number 19.
Item?
Everything is 21. Item 21.
দেখুন তো ওই স্পাইরাল বাইন্ডিং গুলো আছে না একটা স্পাইরাল বাইন্ডিং আছে ব্লু কালারের একটা স্পাইরাল বাইন্ডিং আছে Yes, please.
It's Act Miller to provide for General School Service Commission. Object of the Act Miller, I humbly submit, is to find out or select suitable persons as teachers of the government school. That is the object and purpose, to select suitable persons for government. Now kindly come to 8, Section 8. Manner and scope of selection of persons and procedure for conduct of business or commission. The manner and scope of selection of persons for appointment to the post of teachers shall be such as may be prescribed. Prescribed means by rules. The Section 2 provides the prescribed means by making of rules, not by regulation. Not by regulation. The prescribed is defined under this, as usual, Lordship knows definition. Fine, Section 2K.
Yes. Enter the.
Second.
Yes. It's at page 495 of the compilation part 1.
Yes, please.
The manner and scope of selection of persons for appointment to the post of teachers shall be such as may be prescribed. See the next paragraph. The procedure for the conduct of business or commission shall be such as may be provided for regulation. So, regulation and rules operate in different fields. This I am pointing out now because the argument was made by some of my learned friends that these rules are violative of regulations, isn't it? That's why I am pointing out, operate different fields. And I'll come to later on. I showed you the rules provide that the regulation provides any rules will be, regulation will subservient to the rules. In case of conclusive, rules will survive. That is also position. But that is argument come later on when we deal with this. Section 8 is as may prescribe. So delegated power. Then section 17. The two sections are referred to in the rules. At page 497 of that compilation. State government may, by notification, make rules for carrying out the purposes of this act. Purposes of this act. In particular, without prejudice, terms and conditions, those are things, other things. And regulation now 18 without. Central government may, with the previous approval of state government, make regulations not inconsistent with the provisions of this act or the rules made thereunder for discharging the functions of the commission under this act. Central commission may, and makes it very clear that the rules and the regulations work in different fields and regulations are subservient to the rules. So no good argument that the regulation and the rules are inconsistent. If that is so, rules will prevail. But argument has been made elaborately, regulation, etc. Regulation, rules, new argument. Regulation ultra values the regulations. Rules are ultra values regulation. Inconvenient regulation. Their argument, I do not know whether that case is made out in writ petition, but that argument has to be rejected without applying in further mind. Now, this is the position. This teaching experience has it got with the suitability of the teachers, selection of teachers? That's the point. Now, firstly, giving some extra marks for teaching experience has been very usual. Is not only this commission. Various other institutions have made similar provisions. You might not take our affidavit. We have given some of them. Dr. Guruswamy also mentioned that UGC regulation rules. And we have in our affidavit.
Affidavit in opposition file.
বলো
মানে একটা affidavit in opposition file হয়েছে। এটা রাখুন আলাদা।
না কোন প্যারাগ্রাফটা আছে ওটা প্যারাগ্রাফটা দাও আগে।
Filed as Shoykot Montu. Affidavit in opposition in Can 1. The name of the party is Shoykot Mondol, the added respondent. Can 1 in this matter? Can 1 in Lubana. In Lubana, opposition. I don't find the opposition. Has it been recorded in any order?
What the record?
Monday.
কি বলতেছো আমি দেখি দর্শক কি বলছে শোনো।
On Monday, it was listed as item number 20, Malad.
Yes, I can see it's recorded. Can 1 opposition filed. Can 1 এর oppositionটা কোথায় আছে দেখুন তো কার সাথে গুলিয়ে গেছে। Point out from there.
বেশ দর্শক কি বলছে শোনো।
What you want to point out?
Yes, we want to point it out that it's not the West Bengal School Service Commission.
So you've annexed documents.
The annexed documents of various other universities granting the experience.
All right. I take it. All right.
আপনি পাওয়া গেল না?
It will be found out, sir. It may have gone mixed up with some other file, but then I take that it is a usual practice.
That we have stated at page 8, paragraph Roman 8.
All right.
It has been marked as annexure D.
And the annexure B.
Not B.
No, sorry, B no. D. At his annexures are at page.
The relevant pages.
Yes, sir. Page 60 onwards.
All right.
আর অনেকগুলো আছে এটা কি প্রথম?
প্রথমে
Firstly, Miller to a given. এটা কোথাকার এটা কাদের? Register USS.
This is University of Karnataka.
First is page 60, University of Karnataka. They have granted experience in teaching is 5 marks. They have granted. And the next instance have given the assistant professors, etc. Higher education, F2 department. Page 65 again. Page 65. The Tamil Nadu Collegiate. Education Department, Tamil Nadu. They have given this experience, teaching experience, 10 marks.
This is page 71 and page 71.
And again, another one, page 71. That is experience, teaching experience. We are giving about 3-4 universities.
All right.
ওটা দিয়েছে, 3টে দিয়েছে। গুরুস্বামী ওটা দিয়েছে।
Page 49.
পেজ দাও।
No,
It's good.
another example is cited at page 49 of our affidavit in opposition.
Yes.
We have given 4 instances. Dr. Guruswamy has also given,
Experience in UGC.
has given a list also, addition to that. In his compilation is higher education regulation, UGC notification, 435 at page 485. Therefore, my humble submission is, it is usual, I think unusual, for giving benefit of teaching experience for appointment of teachers in the government school. Yes. Now, Milord, it is not the case that in a appointment of, let us say, a footballer, a teaching experience is made a criteria. Then one can say no reasonable nexus for appointed footballers. But this is a case of experience as a teacher for being appointed as a teacher, appointed teacher. Therefore, there cannot be a dispute. It has got a reasonable nexus with the purpose of the act to find out suitable teachers for this. Now, this can be subdivided in many ways. If a rule has made which has or a marking system made which has reasonable nexus with the object and purpose, then that rules, if it incidentally benefit one class of candidates, that will not amount to bad rules or bad rules. Then comes their argument that all candidates here, as if fresh applicants and those, they are as if they are all equal. I am striking a root of this argument. They are not equals. See, my lord, why I say they are not equals. Firstly, my lord, the fresh applicants are not equal because they have no teaching experience in government school. If the applicant. Number 2, we have passed selection test of 2016, which teachers with freshers have not done. They have not passed any selection test of 2016. We have taught in the government school without any blemish, and that which they do not have. So, my lord, they are not having gone through the ordeal of selection test of 2016 and having come out successfully. They cannot claim they are not equal. They are unequals. Candidates are unequals. Classification date, the fresh applications are made with the full knowledge that if they do not have teaching experience and those who have teaching experience, they will get 10%. At the time of filing of the application, for selection, they did not raise an objection to this rule, the clause of that selection. No challenge was made. Knowing fully well that this discrimination, alleged discrimination, is being made, they have, without any prejudice, without any fetter, have joined the selection process. Now, this is one, they have knowingly done it, it's nothing clandestine. Had this declaration been made teaching marks after admission of the applications, then thing would have been it's knowing fully well. Now, next question is that can or those candidates who had not gone through the ordeal of 2016 selection process or those candidates who have not gone through the ordeals of 2016 selection process can be treated equally with those who have gone through the selection process and those who have been under order of Supreme Court is empowered to appear again, appear in selection process under order of court, Supreme Court. Therefore, they are not unequals. And if they are treated equally, that would have been violative of Article 14 because unequals cannot be treated as equal. We are a different class created by Supreme Court order, untainted class. We have suffered the 2016 selection process, all the we have been given some benefit by Supreme Court and we are having express liberty given by Supreme Court. So we cannot be equated with the other applicants who had not gone through the ordeal of 2016 selection process. And had it been done, it would have been treating unequals as equals and would be violative of Article 14.
Why did you not challenge the this rules and submitted that you cannot be treated equally with the freshers? You all could have come up with a challenge.
I don't have a challenge. I don't challenge. Whatever right is given Supreme Court, we want preservation. And my argument is rule is in terms thereof. Rule do not take away any of my rights or benefit given by Supreme Court. Why should I? Oh, I'm trying to correct it. I'm told, please, I didn't know.
If you kindly come to page 9 of our affidavit in opposition, we have given a chart of the WPA numbers wherein we have opposed to the said rules, my lords. But at that point of time, all our writ petitions were dismissed. It went up to Supreme Court also. The Honorable Supreme Court also dismissed the applications, my lords. We wanted for bifurcation of the rules, my lords. 2016 process should take place separately and 2025 should.
Right. The process is changing.
Yes, my lord.
We want that, but held not entitled to it. And we accepted that.
Are the orders of the court annexed?
It was hard along with the Urnima's matter.
Yeah.
Ultimately, all the matters culminated in the 26th order, where liberty was granted to everyone. There are two sides to approach before your lordships.
But there is no challenge
Yet, because
at least there is
because
no
there is a
challenge.
difference between abilities of the councils to come very lightning speed and maybe little bit of slow. Because today it's today hard December. Just matter.
Anybody with lightning speed with the challenge of the regulation from the old set? Not aware.
My lord, in fact, they held a conference with me also. I
In
suggested
stage of preparation.
it is in the stage.
All right.
Because the order, the SLPs which were there, some of the SLPs were with regard to grant us certain relaxations, because otherwise once you club it, what happens that we also lose.
Certainly.
We also
certainly.
lose, because we were under the impression whatever happened there would be limited to us.
Obviously.
So those are also there.
Bhala is the old sale, waiting candidate.
So means our prayer for being a separate selection test in regard to untainted candidates was not accepted by the court. There will be no separate selection test.
Some writ petitions are in the pipeline.
Yes.
Some are in the pipeline. You can think over.
So we did not claim a separate selection process. Court has said so. There should be one selection process. That's held so.
The court never said there will be one selection process.
Court,
Because that was exactly your challenge.
court says that regard to untainted selection should be separate selection test in regard to untainted candidates of the first selection level to second. That we wanted it a mandamus declaring that. Court did not grant it.
Yes.
So there will be no everybody will be tried under the said rules of 2025. Everybody will be tried under the said
Is it
rules.
proper? Is it proper?
It is court has said so. I cannot say improper.
No. The Supreme Court has granted liberty to file fresh petitions, and everybody who has any grievance can approach the court. So you think it over.
But this order High Court refused. Supreme Court rejected SLP. So Supreme Court approved of this. That this rule, selection process, will govern both. With eyes wide open, that a 10% mark is allotted to a teaching experience. This is important. With eyes wide open, that 10% mark will be allotted for teaching experience, a maximum 10% mark.
All right.
So this is no longer permissible for them to raise this contention. The 10% mark should not be allowed to for teaching experience.
Should not be allowed, is not permissible.
This is no longer permissible for them to argue that, because court has said same rules will govern both. Selection process, and it was then clearly stated in the rules, teaching experience 10%. That was the time for objecting for those who had said that I'm fresh application makers, that no, that should not be done. Teaching, no marks should be given for teaching experience. That was not done. They submitted application with knowledge of this teaching experience, 10% mark. But most important thing is, therefore, the conduct is this. The midstream, when the election, they have appeared in the written test also. Thereafter, they take the point that teaching experience should not be counted at all. Whether they can be permitted to urge the point. After having joined the selection process without any objection.
Yes.
In other words, can they ask for change of rule of game after they have joined the game and game has progressed? In our submission, should not be. But apart from that, we submit that is that this has no merit on substance, in substance. Why? They have not shown and not even argued that this teaching experience in a government school has no nexus with the selection of teachers for government schools. If the nexus is established, end of the matter. It cannot be arbitrary. Incidentally, some party may be benefited, some party may not be handicapped. As I give the instance of many things, not in the tender matters, usually 6 crores capital. You have second, maybe you have supplied similar goods to other government institutions. Therefore, those who have not supplied similar goods will not get get open, cannot. But those have been held to be valid. Whenever those kind of conditions had nexus with the object, if the this work involve 10 crores or more. Similar main criteria, they have not argued. There's no nexus with the object. Next, I suppose, 10% out of 100 is not disproportionate. Is not nobody is disproportionate mark. And in fact, Milord, several candidates who had no teaching is fresh candidates, they have scored marks more than the untainted candidates in the last written tests and the so it will not, you cannot say it will not tilt the balance. It's not so had it been 50%, things like that. It's not.
There are scores of matter over here where only 1 mark is making the difference.
Yes.
Whether to participate in the interview or not. And 10 marks you say will not make a difference.
Yeah, that's 10 marks, Milord, is not the. Then there are 10 marks for academic qualification. 50, 10 mark academic qualification. With
academic is 60. The writing test is 60.
no, academic qualification, honors will BA, MA, B.Ed, etc. Huh? Yeah?
Written examination is 60.
60.
Written examination is 60.
Let us see the schedule. Take up the schedule.
Academic is 10 and teaching experience is 10.
60 written test is the maximum. It is written test 60 marks out of 100.
Right. So we are not looking at the 100 stage now. We are looking at 60 plus 10 because here the interview list is published. And if you do not qualify, you do not go to the next stage.
That's the time. That is when you come to the address your lordship. At what stage the marks will be allotted? What's the purpose of interview list? To shortlist the candidates.
Right. So
Right.
the marks are added now.
Added now,
So
yes.
60 plus 10.
Even by plus 10 educational qualification, 10 marks, 70.
70.
70. And then, Milord, out of 80, out of 80, 10 marks for teaching experience. It's not disproportionate. It is, nobody has said it disproportionate. So reduce it to 5 marks, nobody has said that. And in another case, if 5 marks is allowed. So, but let us, I'm arguing, submitting the arguments. Arguments, they have said no reasonable nexus. That nobody has argued. Nobody argued disproportionate. Is a case that's a course made out in the writ petition. But even then, now in the affidavit said, we are given instances where fresh candidates without this teaching experience have got more marks, total more marks than untainted candidates. So but this 10% mark is not a unsurmountable hurdle. It has been crossed by many fresh candidates. that will also give me a list at page 44 of our affidavit. Of fresh candidates. Category number of fresh candidates called for interview in different subject. This is list. How many?
Total is 9488 out of
No,
20,000.
similar. Page 44 also you got it. Total number is 9,488. Out of 9,488 candidates, despite having no teaching experience, have been called for interview. So it has not factual support also. Arguments have been made in the petition. First of all, say why it is disproportionate, factual expression, etc. And now we are showing the fact as it actually happened. 9,488 candidates. After that, the argument disproportionate cannot be considered. They cannot argue. This point has not been adverted to by the learned friends. Now, place similar is not this. It has reasonable nexus. It cannot be called disproportionate or unreasonable. If 10 marks will be 5 marks, nobody's argument is that. Now, then, Miller, let us see what other grounds have taken for teaching experience marking. See the other grounds they have taken. They have what have argued. Yes. I have given instances of other institutions have similar mark for teaching experience. That we have given. It is not their case in the petition. That is very unusual. No other institution has allowed. No such case.
Yes, what next?
Case. Then teaching experience not mentioned in Rule 2/2016. This argument made. What follows from that? That it was. Its point is because it was not mentioned in 2016 rules. Then when new rules are framed, it cannot be mentioned. Then what's the purpose of making new rules? Now, please see on this aspect the judgment they have themselves cited. This standard of this reasonableness vary from year to year. They have cited the judgment reported in AIR 1986 Supreme Court 1444, paragraph 4 they have cited.
Yes.
See that paragraph? 4. Copy it over there.
It has been cited in that compilation. Bhim Sarkar.
It has, my lords, it has been submitted by the petitioners in Bhim Sarkar and Lubana.
ওই তিনখানা যেটা ছিল
কথা বললি তো টেলিফোনে চেক কর
Which one?
AIR 1986 Supreme Court
1444.
1444.
Yes.
So the judgment on the Premises Tenancy Act. Those who have tenant paying rent of 400, they will be out of Tenancy Act, and others will be. This was the case. Now, Lordship knows now on the Premises Tenancy Act, there is the on the present act also. There have been. And at that time, in old time, court considered at this that this was not reasonable. Why? Please me not. Come to Millard, page 1448, where Supreme Court is saying, relying in middle of that paragraph on left-hand column.
How does it start? How does the paragraph start?
Oh, SC is okay. Paragraph 4 starts, the counter affidavit does not exist.
All right. Yes.
And that is long paragraph, the only paragraph they relied upon. If you turn to the paragraph and come to the where 1984, 1 SCC 222 has been referred to.
Yes.
That portion. As held by this court in the 1984 1 SC 222, a provision which was perfectly valid at the commencement of the act could be challenged later on the ground of unconstitutionality and struck down on that basis. What was once a perfectly valid legislation may, in course of time, become discriminatory and liable to challenge on the ground of its being violated of Article 14. After referring to some of the earlier cases, Justice Venkatamaya said, the garb of constitutionality, which it may have passed earlier, has become worn out, and its unconstitutionality is now brought out to successful canon. Justice Rangam, etc., invite attention to some sentence in 74 Supreme Court. Then, what it says, then after quoting the observations, these observations were made in 1974, soon after amendment of Act of 73. They are made in different contexts and not etc. So, the test of varies. What was considered not necessary in 2016 may become necessary in 2025. The gap of 9 years. So that is because the 2016 rules, it has not make a teaching experience. It cannot be mentioned in 2025. This judgment has been followed, paragraph 4, in AIR 2005 Supreme Court, 2677, paragraph 58. The judgment of 5 judgments. Copy down, Dr. Quick. Paragraph 58 at page 2698. Itu. Itu. It's a very atokura judgment, no? Huh? It's paragraph bar kore daw. Because in SCC you are giving SCC online, therefore can you find out the paragraph 58 in Liverpool, London. And salve kottake ei jagata put it. Liverpool, yes. This is also paragraph 58 of the SCC online. In Liverpool and London SP 2004 9 SCC 512, this court observed, referring to motor general traders, another, first state of Andhra Pradesh and others, 1984 1 SCC 222. This is the judgment not of seen just now. The judgment is referred to Ratan Arya and others, state of Tamil Nadu and SCC, and Synthetics and Chemicals Limited and others, and 1991 SCC. This court held at page 608, paragraph 49. There cannot be any doubt whatsoever that a law which was at one point of time constitutionally may be rendered unconstitutional because of passage of time. We may note that apart from the decision cited by Mr. Sanghi, recently a similar view has been taken by Kopila Hingadi, 2003, etc., and John Balmattan, etc. The Constitution of India is an ongoing document. It must be interpreted accordingly. In St. Francis Benjamin Statute interpretation, it is presumed that Parliament intends to the court will apply its ongoing act a construction that continuously updates its wrong wording to allow for changes. Since the act was centrally framed and updating construction, while it remains the law, it is to be treated as always speaking. This means that in its application on any date, the language of the act, though necessarily embodied in its own time, is nevertheless to be construed in accordance with the need in treat it on as a current law. Then page 70 also quoted in construing the ongoing, etc. So, what was not required in 2016 may become necessary in 2025. So therefore, in 2016, we did not make this teaching experience a mark. That doesn't mean if we make it in 2025, that teaching experience as a mark, a 10% mark, that will become invalid. But we have to see, my lord, best thing is see whether teaching experience has an intelligible different nexus with the object of finding out suitable teachers, selecting suitable teachers. That's the main object. What I did not require this teaching experience as a mark, maybe for various reasons. That's what the government can explain, or commission can explain. But will not. That has first to be pleaded. Giving the has to be pleaded. Then the state will be called upon to answer. But if it's not pleaded, no question of answer arises. Pleading is now gradually assuming more importance than it used to have in view of recent Supreme Court judgments. But I'm not on the technicality. Must be some reasons. Why it is? Because it is very, very bold argument to say 2016 it was not mentioned, therefore cannot be mentioned in 2015. This is not an argument by itself. Unless they have made no attempt to show that this teaching mark is very unusual. Nobody does it. And the teaching experience is not a reasonable nexus with the object of finding out suitable teachers in the government schools. Therefore, this argument in humble submission has no leg to stand on. Now, I've already submitted that this teaching experience is not confined to government school in West Bengal. Rule do not say so. Therefore, there is no discrimination. That only government school in West Bengal experience will be counted. Anybody, any come. Then next also kindly consider the rules have been prepared by expert body NCTE. They have not prepared the rules of 2016, maybe, may not be. Therefore, they prepared this rule in NCTE. And
these rules have been prepared by NCTE, by the state.
Commission. NCTE.
The state.
Expert body. State করেছে, but they can consult with NCTE frame করেছে to. Expert body has consulted. Anyway, if I'm wrong, is anybody for the commission correct me? Was the NCTE consulted?
Principal secretary.
Correct me.
Those
They have been taken into consideration.
Principles have been taken into consideration, including NCTE, because NCTE obliges to not recognize degrees. Minimum eligibility criteria.
Ideas have been taken, not consulted.
Not
very good. I stand corrected, Mills. I can correct it. But normally they should have argued first, and I should have been normally. So, some of NCTE ideas have been taken. That is all. Now, but then come to what is arbitrary? What is arbitrary? Well, kindly see 2002, Volume 2 Supreme Court cases, 188, paragraph 25. Paragraph 25. No. ঠিক আছে আমার বেনে ডটকে দিলেই তো হলো Paragraph 25, পাতাটা খুলে দিলেন না কেন? Paragraph 25. It has been pleaded, as noted above, that withdrawal is without any rational or relevant consideration. Withdrawal is government, same thing. It has to be noted that this is the correct line of approach without a rational, relevant consideration. In this context, it has to be noted that the operators in state of Andhra Pradesh are required to pay the same tax as though registered in other states. Therefore, there cannot be any question of irrationality. The test of arbitrary action applicable to executive action do not necessarily apply to delegated legislation. Kindly note this. Applicable to what is applicable to executive action do not necessarily apply to delegated legislation. In order to strike down a delegated legislation as arbitrary, it has to be established that there is a manifest arbitrariness. In order to be described as arbitrary, it must be shown that it was not reasonable and manifestly arbitrary. Not reasonable. Expression arbitrary means in an unreasonable manner, as fixed or done capriciously or at pleasure, without adequate determining principle, not founded in the nature of things, non-rational, not done or acting according to reasons or judgment, depending on the will alone. In the present case, all the persons who are similarly situated, similarly affected by the change. That being so, there is no question of a discrimination. So, therefore, the question is, can it be said to be unreasonable and capricious without any determining principle or nexus? I am humble. None of these tests have been sought to be fulfilled in this instant case. The teaching marks 10% is wholly arbitrary, is unreasonable, or it is done capriciously without has no nexus with the object. It has not been at all sought to be proved. There are other judgments they have themselves cited, which will rely on this field, on this aspect. Other judgments also. I'll come to those judgments cited by them when deal with judgment. I will show from their judgment also. So, this simply saying arbitrary is not enough. Have to be shown. And also, delegated legislation and executive action stand on different footing. Different footing.
So according to you, this rule is a delegated legislation, and as such, it cannot be held to be arbitrary because the Parent Act remains. This is exactly your submission.
Parent Act, object, purpose.
Object and the nexus
is being
and everything.
subserved. It is not being that I'm obliged, Your Lordship. I'll put my submission as my Lord, taking a cue from my Lord's observation. I put it negatively now. It is nobody's case that allotting of 10 marks for teaching experience will prevent selection of suitable teachers. That is to I stand corrected. That argument has to be made and court will satisfy. That allotment of 10 marks teaching experience will stand in the way of selection of suitable teachers. That is, should be the test of the matter. And that nobody has said so. It's standing in the way of. Then, in other words, he has no nexus. It will defeat the purpose of the act or the rules, namely selection of suitable teachers.
Yes.
Next point has been taken that experience of 9 and 10 can consider for 12 and 11 and 12. That's considered. But that 1 minute, 7 minutes, has been answered by Dr. Guruswamy very competently. He has shown the experience in secondary education. Classification is, under West Bengal law, classification is between primary, secondary, and higher. Secondary includes both 9, 10, and 11, 12. Therefore, court cannot be asked to make a classification within class. That is the answer given to Dr. Guruswamy, which I need not repeat. I adopt that. Then next ground attack is
I just let you know that there is one writ petition filed by the 11-12 candidates that the 9-10 experience cannot be treated to be taken as experience for teaching 11 and 12. This writ petition is also there.
that is repeating that answer is
That is a petition.
that's right.
I just let you know.
Therefore, will not therefore
So
teaching
all types are here.
very good. Therefore, will not this argument is based on an admission that marks can be given for teaching experience.
No, the candidates are
That's
job losers.
Marks can be given for teaching
There
experience.
the rule is not under challenge.
And then, but while giving the marks, you find out, did you teach in 9, 10? Very good. I'll give you these 10 marks if you are a candidate for 9, 10. Marks can be given. Enough for me. Enough for me.
You and those candidates are on the same footing.
But that's enough for me. Therefore, not, if it is both as part of secondary education, 9, 10, 10, 11, then why make this classification? Why classification made by the legislature? And how can you ask the court to make a sub-classification? Court cannot differentiate between 9 and 10 and 10 and 11, 11 and 12, because they're all part of one class, secondary education. Court has the rule, our act do not say secondary education part 1, secondary education part 2. Therefore, this approach is not permissible. Is that when the legislature has made a classification and clubbed together 9, 10 and 11, 12, clubbed together to form one class, how can they ask to make it dissect it and make another class? This cannot be permissible law. Right. That was the argument of Mr. Guruswamy, which I adopted. Which argument means I say nothing new I'm arguing. Next ground is taken, level playing field. What is meant by level playing field? I do not know really. I'm not so much level-headed. No, level playing field. I'm trying to ascertain what is level playing field. At the time of being invited to join the selection process, all candidates were told what is the rule of this field, what is the field. If you join this game, this is your field. It will be 100 years or 200 years field or whatever maybe. You will get 10% at 10% if you are have teaching experience or government schools. If you don't have, you don't get it. So level playing field is the candidates must be made aware of the playing field and the rules. Level playing field, what does it mean? It is based on rule of law, the level playing field, that there must be certainty of the rules of game. Level playing idea is based on the rule of law. The rule of law says there must be certainty, the crux of the rule of law. That must be followed. I am humbly submitting the certainty is clearly stated in the rules. You like it or not, don't like it, don't participate. Don't participate. Or to come and challenge it immediately. But we must make the rules of the game certain. That we have made certain. Next answer to this is, that is 10 marks teaching is not an eligibility criteria. That is important. Gates are open to everybody. Had the rule been that only teaching experience persons, 5 years or so much, will be allowed to participate, then thing would have been different. Level playing field, they can know why others are not being allowed. But with all the judgments they have cited, if you find me out, they are all cases of eligibility criteria. Getting, not opening the gate fully, but shut the gate for some people. Eligibility criteria. When I deal with their case, I'll show that the eligibility criteria is to must not shut out any. It is level playing field apply to that, not irrelevant. Then mirror. No judgment has been cited what is meant by level playing field, but we shall endeavor to do so. Then my next point is that the rules are contrary to regulation of 1998. And as I go on to saying the rule ultra vires, rule is contrary to regulation of 1998. Kindly see the regulation of 1998. Similar heading. The regulation, the name is very, very long name. West Bengal School Service Commission procedure for selection of persons for appointment to the posts of teachers, including headmasters, headmistresses, superintendent of senior madrasa in recognized non-government aided schools, and procedure of conduct or regulation. This is for selection of teachers or maybe for madrasa. Firstly, my lord. Now this rule has been made out under section 18. In exercise of power conferred section 18 of the Act, Service Commission may hereby make the previous that Act is quoted. Definition shall have same assigned to Western School Service Commission Act. Now, section 18 also remembers of the Act. Section 18, please come back to me, Lord. Power to make regulation. Central Commission may, with the previous approval of state government, make regulation not inconsistent with the provisions of this Act or the rules made thereunder for discharging the functions of the Commission under this Act. Compare this Rule 17. State government by notification. No, Central Commission is not making that rules. State government is to make the notification, make rules carrying out purpose of this Act. Regulation is made by Central Commission with the approval of a state government. And the regulation cannot be inconsistent with the rules. So in case of inconsistency, if any, the rules will prevail. Regulation cannot make an rules ultra vires. Is on the reverse. Rule can make a regulation ultra vires or not. Secondly, Miller, this regulation operates in a different field, madrasa. And ours is government schools, government schools, not madrasa. So, Miller, it is not a proper argument to make that regulation is even if it is assumed to be contrary to any regulation, rules, the rules will prevail. So the argument has no leg to stand upon. Next, similar to the next point, they are arguing that they have argued rather. They have argued that actually point baki ache. No, আমাদের point. ওদের রুল গেল teaching experience বলেছে level playing field, experience of 9 and 10. Let me now, Millard, start dealing with the judgment they have cited. From those judgment, how does it help them or help to support the humble submission of mine regarding proposition of law? The 2025 7 SCC 705, paragraph 39, they have cited. Mr. Vikas Bhattacharya just cited this judgment. Okay. আমার কপিটা দাও, আমার কপিটা দাও। এটা আমার কপি।
2025 7 SCC.
2025 7 SCC 705. Yes, Minot. 7. It also be given Supreme Court cases or the SCC online?
Find out.
SCC, oh, yeah.
Find out. Your Lordships may permit me, I give you a copy right now and have a copy.
No, okay, there's a mark for them, no? Court will mark it.
If it is here, then it must be here.
Lordship needs at least 4 or 5 juniors. Hand over.
Yes, 529, it's there.
আমার বিপ থেকে দাও না, এই যে আমার বিপ থেকে জামিনটা বার করে দাও, আমার দাগ দেওয়া তোমার
compilation serial number.
Yes, I've got it.
18.
529. Yes.
When you got it, Miller?
Yes.
Paragraph 39, Mr. Bhattacharya has relied upon this. 39. It cannot be gainsaid the factors of when, which, what, who, and how that are associated with a recruitment selection process is the prerogative of the recruiting authority and the selectors. However, this is first prerogative. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same. So, I rely on this. They cannot make selection contrary to the rules. if any, as well as principle of absolute fairness and complete. Because we'll point out here, in this case, there's no rules. Also, you find that in paragraph 40, can you go to paragraph 40? Then I'll come back to paragraph 39. In this case, there's no rules. There's a main distinction. Be that as it may, drawing from our joint experience on the bench, we can say with some degree of conviction and authority that conducting recruitment process in terms of executive orders and in the absence of statutory prescribed standards more often than not invite avoidable litigations. There are no rules were there. They now come back to paragraph 39, as well as principle of absolute fairness. Though it is true that the law does not postulate a fetter on the authority of the employer state, and it is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in the absence thereof. It is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidates aspiring for appointment have to pass through in order to be placed in the select list? Who would be the selectors and how weightage is to be given to each of the testing methods? A great deal of credence is lent to the process if it is fairly and transparently conducted in accordance with rules, whatever be the source, without the slightest hint of any bias or favoritism or nepotism. Full stop. So, my lord, the rules must set how weightage to be given to each of the testing methods. Weightage to be given to what? It must be disclosed. Then, normally, it is not for the courts to interfere unless the process smacks of malafide. However, the right to be considered for public employment being a fundamental right, it will be safe and prudent to have recruitment rules to govern the process of selection so that best possible talent is appointed in public service. That's the Mullah I'm saying. Suitability and best from service. Teaching experience for being appointed as a teacher. That's what that's what I'm saying. Obviously, assessing the merits of the candidates aspiring for public employment on the basis of a prescribed standard would not only provide a level playing ground field. This is for each of them. There exists excellence of any institution to which appointment is to be made would depend directly on the proficiency of its members, staff, and that would in turn depend on the quality and merit of those who offer themselves for selection and ultimately get selected, necessitating the selection to be conducted without any hidden taint or masked malafide. Last but not the least, having regard to the present times when the corruption has been held to be a work of life by certain responsible citizens of the country, very sad thing, but correct. It would have been desirable if the process of recruitment of 104 candidates was conducted after framing of recruitment rules and also prescribing the written examination to keep the process absolutely above board. It supports me, my lord. I respectfully support me because in this case, my lord, there are no rules. There are rules. And selection process was challenged. Not any rules giving any weightage to anybody. Now selection process, subject matter of challenge. But what is challenge is giving weightage to each and every testing method. Which testing method. And court says it is a government priority. Priority doesn't mean freedom to do anything. That I agree. But then it comes to be, court will start with a presumption of validity. This is law, 114E, Evidence Act also, sorry, should.
How much more time are you likely to take?
But can you tell me how much more time I should take?
It is up to you.
As I should take. Your Lordship is the best judge.
It is up to you, sir. You are nearly over
May
because
I continue tomorrow? May I continue tomorrow? Or
tomorrow I don't
or
think.
whatever date?
Maybe on Friday it will be all right, but not tomorrow.
Friday or Thursday? Not possible.
No, sir. Tomorrow I've got applications and it will not be possible.
Okay. Friday. In the first part of the morning, will it? The Friday I've got one small matter for half an hour at 2 p.m. That's why I'm asking, Milord. I can ask the learned judge to push it off, or
Let me see.
my preference of this matter, Milord. So many persons' life is depending on this matter.
Certainly.
That's why if Thursday is not possible, then Friday, Milord, give it pretty high up. So I can finish before lunch and recess.
This matter is fairly at the top.
But depends on the other matter. Some unexpectedly, legitimate expectation sometimes is not fulfilled. Some matters takes more time. In the found that item 7 was going on for a long time. I was waiting for this. Anyway, kindly, court's convenience come first. Then I shall adjust, have to adjust.
Because you are already over, just distinguishing
That's right.
the
I have to
judgments.
deal with the judgments.
Possibly it will take much more time.
I'm only answering the argument, nothing more. I go point to point. My task has been somewhat reduced by Dr. Guru Swami that has given. Thank you.
All right. Next is Mr. Dhar's turn. Is it your turn next?
Yes.
Mr. Dhod,
In that case,
my deficiencies will be made up by Mr. Dhod. My deficiency will be made up by Mr. Dhod.
If there is any. Hello, that would be one line order, identical order. In there is a little separate applications, even better candidates who got the benefit of they had an earlier job. Now, because of these confusions, many of them, the headmasters are saying that let the court decide, thereafter we would allow you to join. So these are the circles. So they made an application. So kindly I just
let the court decide. The Supreme Court has decided already.
Supreme Court has decided for
reverting them.
No, question is whether many of them, there are total 8 counselings. Now, majority of those counselings, in fact, tainted were mostly in the first counselings, which was, but that's nothing to do with. Now, majority of them are from first counselling to 7th counselling.
All right.
Now, if Lordship holds that those who were appointed after second counselling, because first and second were within time, third, fourth, fifth, sixth, seventh, those were
has not been argued also.
I will argue that why I say that the Supreme Court has 100% clarified that who are tainted and who are not tainted.
That is different. I'll come to that.
But that matter is coming on 10th, I suppose. The matter regarding expiry panel candidates, it is coming on 10th before your lordship.
No, expiry panel.
That sir, you can leave.
I can go.
Yes, I'll keep it on Friday.
Friday, in the first half.
And at a higher position in the list so that you can make your submission. And in case it doesn't take up, then it is an understanding during recess. I'll take it up so that you can be relieved in the second half.
Yes, but second, I don't. That will be take half an hour maximum. But some court has a practice of hearing matter for short while, in a piecemeal manner, for the benefit of the lawyers and to detriment of litigant.
In this matter, I
may take my last leave.
Yes.
I'm seeking kind leave to correct the fact sheet of the affidavit in opposition. This matter,
You have mentioned the wrong number.
no. The name has been
Wrongly.
fact sheet. The fact sheet.
What is the name that you have mentioned?
Saikat Mondol is the name. The applicant who has been added as a party.
Yes.
The fact sheet it has been wrongly typed as Shipramai.
দেখুন তো এটা খুঁজে পান কিনা?
Yes, but it has been added up to your lordship, madam.
Today?
Yes.
তাহলে দে ওপরেই আছে।
Due to learned advocate general is in the
এনাকে ফেরত দিয়ে দিন। এইটা এনাকে ফেরত দিন। মিস্টার ধরকে এটা ফেরত দিন।
learned advocate general is in the
Oh, 1 minute.
VC.
1 minute, 1 minute. This was not required. Mr. Mitros Jr. will please take this back. This was not required. Yes. The AG want to submit something?
May I mention, because I mentioned, because item number 13, my lord will remember that where matter will be, my lord, whether it's sat or
The tribunal matter, my lord, your lordship was pleased to release the matter initially on my submission that it ought to go before the tribunal. My learned friend's contention was there is no judicial member in the tribunal. My submission was that one must file a petition before the tribunal and then come to the High Court. My lord was pleased to prima facie agree with me and pass an order. Thereafter, I think the matter was mentioned once again and today, my lord, it's appearing in the list.
Learned AG, 1 minute. May I finish with this and then hear that?
Right.
That will be beneficial for, because otherwise, my lord, it will be jammed. I will cite it.
So please wait, let me pass an order in this matter.
Item number 13, it may be.
Item 15.
Yes, that is jurisdictional issue alternate.
But submission made on behalf of the applicant in Can 1 of 2025. As the recruitment rule pursuant to which the ongoing recruitment process is taking place under challenge and the parties are at the stage of advancing arguments, the commission is directed to publish a public notice. Commission, please, are you here?
Yes. We are here.
Oh, yes, you are turning that side. I missed.
In which matter? In 515.
The commission is directed to publish a public notice disclosing pendency of the writ petition, clearly indicating that the fate of the recruitment process shall abide by the result of the writ petition. Stop. The said notice is required to be published so that none can claim any right or equity even after the conclusion of the selection process. Stop. After the selection process, no, not even after. If the selection process concludes prior to passing a final judgment in the instant matter. List for further hearing, 5th.
Any outer limit for publication?
Do it immediately. Why I say? Why I say so
that we are not in any difficulty.
None is in any difficulty.
Right.
That's it.
Otherwise, see, we are in the midst of a hearing.
And only one submission, it is understood that all these my learned friends are going to make submissions on Friday in item number 15.
Not know, but
some of them. So, my senior, Mr. Bandopadhyay, is in difficulty on Friday. Whatever happens
on the next day. Yes. I'll hear.
But I'll be addressing after. Kindly permit me to address after Mr. Dhar or before Mr. Dhar, whichever your lordship feels would.
No, there was an understanding that lordship that
you on the first day
you are a neutral.
You wanted to argue after all these applicants. And
Right. Very good.
Applicants, I don't think Friday will be complete. Mr. Sannal is there.
It will certainly not be complete, and that is the reason today's publication order is being passed. Because Supreme Court has set a deadline. the commission will be bound to follow that. Now, Supreme Court has also passed on a very onerous task on the court to hear all these matters and decide. And within 1 month, it is absolutely impossible. Not even 1 month, 3 weeks prior to the vacation. It is
Have only,
impossible.
18, 19 working days.
So it's absolutely impossible.
madam.
So many
This is-
candidates
this is-
to be heard. It will certainly take time.
Not even 18, 14 working days.
So whatever, let it be made public that this matter is going on. None can claim any equity, and nobody will at least feel that no, I didn't know that the matter was there. Let there be a public notice.
Yes.
And then whatever happens, happens.
Correct.
But it will be.
Yes, now the Advocate General, we are over with 15.
In Bhim Sarkar, your lordship is not passing anything.
Order will cover.
No, he wanted to come up with that application CAN 7 or something.
Wait, I'm hearing Mr. AG in some other matter. Just wait, I'm not rising, sir. You all hardly leave me at 1:15 and at 4:30. Hardly. Yes, AG.
I think Mr. Shamim wants to say something. I am
I
okay with
think
the matter being fixed on any day, Milord, as per the convenience of the court.
Yes. I am.
It's absolutely inconvenient.
So next week, or because that matter is going on, and another thing is that, my lord, because it's fallen from, my lord, from this court, my lord, there is public notice regarding other matter, my lord. They make this public notice in 2 newspapers. One is that in English and
Published in the official
website.
of the
Yes, as my lord deemed fit.
যেখানে বললাম না published in the official
Oh,
website
yes,
of the
madam.
commission.
Yes.
That is the
that-
most
yes.
transparent way.
More transparent.
But then item 13, no date fixing.
Yes, my lord.
Sorry.
Then, my lord,
Item 15 you want?
post
For correction of back sheet.
Back sheet.
my lord, item number my lord, item number
পাওয়া
13,
গেছে?
then
আপনার oppositionটা কি পাওয়া গেছে? টেবিলেই থাকবে। এটাকে আগে
my lord, then item number 13 may be posted in next week. Item number 13 may be posted in next week. Next week or?
let it remain.
Oh, yes, my lord. Yes.
And as and when it appears, we can
yes.
pass necessary orders because changing the position of the list will be difficult.
Should I keep the opposition with me? Because I was thinking the difficulty in finding out. Now I have served to the other side, so that's why I was saying to my learned friend, it would be better that instead of, because burden we can clearly understand. So it's served on, I will give, that would be better.
What thing?
The oppositions are there,
Yes.
affirmed, also served to the respective parties.
Yes. As and when matter comes up, you.
That's item.
Yes,
So that it can.
I'm not passing order
Yes,
in any
yes,
matter. It's
yes.
only in this matter, item 15, that the order is being
Yes,
passed.
yes.
Fact sheet power আছে? Vision.
I say that nothing in item number 21, kindly pass 1 line order, add can number 7. Do not hear me today. Once I finish for everyone, thereafter there is a little small group who stand even higher footing. So today's I am praying, kindly allow the can.
Allow. But I am not allowing. Is the can there in the list?
It is in the list. It is in the list.
Let it take it
Fine.
that it will be.
I understand.
Be prepared.
Correct,
Not
correct.
passing any.
I understand. Well,
because any order
Going-
passed.
Going, the file will go. Yes.
Signing, checking.
Ma'am, I do understand.
There.
Once you finish all, then.
In can দেখে নেবেন of 2025 correct the back sheet of the affidavit in opposition filed in court today. আজকে কি একটাই opposition file হয়েছে না আর কিছু file হয়েছে?
We have filed in Shishi. Item number কত শিশিরটা? 19.
আমার কাছেও আছে তো তা?
I file it today, please take it.
It is already taken on
in
record.
fact,
and He has kept it with the record.
In
You
fact,
have 1 line.
here I also have affirm sub, but I have not
All right,
given
then
because
fine.
it is better I keep it. Otherwise, my lord, it will be difficult for the
পাওয়া গেছে
officers.
রেখে দিয়েছে
Yes, yes.
As and when matter comes up,
Then we'll give.
And your lordship
Yes.
has to allow.
please do.
Hey.
Otherwise, it will not be recorded. It
I
will
understand.
Very
I
good.
understand.
Yes, yes.
Why is he, what is your name? Why is your name not reflected in the order sheet? I do not see his name in the order sheet. I do not know the reason why. You put in the slips adding names of persons who are not there in court.
Just remember this, when you will become old like us, you will
No, Mr.
cherish.
Dhod is not old, Milord. I
No,
beg
no.
to differ.
I'm much older. I say that.
Taking the example
No,
for himself.
I'm saying.
No.
I say.
Let me turn this off,
No,
Milord. I'll say.
I say that when we'll Milord become very senior one, we will cherish this moment. You'll understand the human part of the justice delivery.
Good.
ঘুরে বেড়াতে পারতো নির্দিষ্ট কোনো একটি অঞ্চল ছাড়া, তাহলে দেখতে পেতেন যে বাংলাদেশে সংখ্যালঘুদের উপর আক্রমণের প্রতিবাদে বামপন্থী